Hey, your lordship. Item number 5. I am on behalf of Renal Sharma. I could say that the Renal Sharma would not be able to appear before this court. So matter may be adjourned for today.
We have heard this matter. Why should we adjourn?
He is going
Hmm?
out of body. He is going.
No, we have heard him. We just want to see the records. There's no requirement of further hearing. We have heard this matter.
So
BRPL matter, isn't it? BRPL.
Yes.
Selection.
Yes.
We have heard this. Who was appearing for BRPL? Mr. Chaudhary. Is the records there? You'll be here. When we'll pass the necessary orders. If required, we'll adjourn, but otherwise, we have concluded the hearing. Let us see. Yes, not now.
I beg to mention item number 2 much.
Item number?
2. Only
Rejected. Yes,
I am there in the
rejected.
Mr. I beg to mention an MC 63 to the 2023. Basically, this restoration petition,
Okay.
and the WPC was dismissed for non-prosecution of the advocate lordship in 2015. Therefore, the case has been condoned, but this restoration petition is yet to be heard. And since it is a long pending case, so kindly it may be listed on 26th Friday.
Bench 5 matter.
Bench 5 matter pertaining to court number 30.
Oh, this is not bench 5. We're bench 3 matter.
Bench 3 matter pertaining to court number 30.
Okay.
Document for listing of a WPC for admission purpose on
WPC of which year?
2023.
23. Why do you want out of turn listing? What is the urgency?
It is supposed to be listed.
No, that
after
is not
the-
the urgency. What is the urgency? What is the subject matter?
regarding
Suspension of what?
suspension from job,
From service.
from service.
Is there any interim order?
And
Okay, we'll have it on Monday.
a similar prayer for another WPC.
What is it?
WPC
Subject matter.
2023
Subject matter.
suspension.
Okay.
And one more,
No, third is what?
same WPC
No, WPC is for suspension.
suspension.
Okay.
Highly object.
For listing of a matter pertaining to pension matter whereby the petitioner has been getting provision, but
Matter of which year?
23, my lord.
Pension matter. Okay, Friday.
I'm praying for listing of this matter for admission on coming Friday. Matter pertains to non-release of pension.
What is the stage?
As the only motion day, it was came. After that, it has not been listed.
It is
Last
at the
listed
stage
the-
of motion or admission?
Admission.
Pension matter. Matter of which year?
2020.
Okay, Friday.
Obliged.
Yes, madam.
I beg to mention for this petition
Of which year?
21.
21. What is the subject matter? Why do you want a listing by mention memo? You should know the subject matter, basic fact. Why have you come to mention? You should know that. Not like this. Yes, madam, next.
Item number 34 of court number 30. It's motion action. It was mentioned and listed today.
Funny. Deferred. Acha. What is your prayer, madam?
There is an urgency related as it relates to transfer of the petitioner.
Hmm.
It will become instructive. So it may be taken up today or
It is for motion.
yes,
Item number?
34.
Supply.
Sup-
Supply, asana? 34. Okay, we'll try. Record 20, believe it. Okay. Okay.
Apply.
If I beg to mention for listing of a WPC pension matter,
Of which year?
of 23
Okay. Monday next.
next month.
Yes, Mr. Lordship, like to mention that that regarding that past association, we are halting Dibrugarh Metal Road.
Okay.
Lordship allowed by the next week, the Lordship was the division.
No, this is a bench tree.
Yes, Lordship has made it part third.
Is it part heard?
Yes, Lordship. That's why only last occasion it came up before the Honorable Court 47.
Part heard? We
Yes.
don't make part heads. Huh?
I ordered it.
part heard isn't. This court never makes any part heard unless the matter is fixed tomorrow.
Lordship.
But if it comes before us, we can take it up, but we cannot take it out of turn. We are having bench tree.
Yes, Lordship.
It's not bench tree.
Because the Lordship was taking the matter 5-6 occasions on the Lordship. On a specific date, the Lordship.
We cannot break the roster.
Yes, sir.
It will be, if it's a part heard, if you have ordered part heard, then it will come, otherwise, sorry.
Yes, sir.
Hmm.
But there is a order Lordship made in a poll Lordship written for further date. I had ordered that.
You can, you file an application before the registry. We cannot pass an order like this.
Okay.
Yes. Yes.
Hey, Mr. Lord, my lord, dear. The petitioners, my lord, all have retired.
Drawer আছে এইকেইটা পেট কেইটা নানে কি কৰে drawer নাই yes
The petitioners hearings are all divisional accountant, my lord, in the SPC, my lord.
okay
And all have retired now. They have retired. Now, before, my lord, years of their retirement, my lord, they were to give promotion to the post of
drawer নাই
they were supposed to be given promotion to the post of account officer, my lord. But they did not give. And rather, my lord, the department has directed them to appear in the written examination, which was an earlier, it was not done. Your lordship will find the direction made by the,
how many petitioners are there
here there are 4 petitioners, but
you are divisional accountant
yes, ma'am,
division accountant
the divisional account
in STC
in ASTC, Assam State Transport Corporation.
yes then
So, my lord,
you
they
want it is the feeder cadre for the post of accountant
accountant, my lord.
You
The
did-
accountant, they are to be promoted, my lord.
so
The-
from
the-
divisional accountant you become accountant
Yes, my accountant.
next post yeah, okay
Yes, my lord. So, there are vacant posts, but in the meantime, my lord, the respondents were not appointing the petitioner. Rather, the petitioners were directed to appear in the interview. That is, your lordship will find page 29, another C.
interview page 29
Page 29, another C.
okay what is this
So here the then name of the petitioner and others, all are divisional accountant, my lord. So the next page 30, your lordship will find. Paragraph,
just a minute please 29 petitioners are there others are also there
yeah, others are also there.
this is 36 2014
Yes, sir, 36.
okay what happened thereafter
Yeah, then my lord, direction was made by this communication, that is page 30.
Hmm.
Relevant part your lordship will find. The paragraph, it is decided to fill up the resultant vacancies of account officer from existing divisional account officers,
Hmm.
for which a written test will be conducted on 31/7/14 at head office, SPC Guwahati.
Hmm.
This is the direction made. Right?
Hmm.
So petitioners, my lord, they have filed an appeal before the chairman. Right?
Yes.
That all along there was no any interview for promotion in the post of accountant from divisional accountant. So they have filed an appeal or representation, my lord. Like here they have written as an appeal. That is 33. So they are to be give promotion on the basis of seniority. They have prayed. Page 34.
Yes.
Then your lordship will find this interview though held, but none has appeared. And what happened, my lord? In the later, my lord, we may say the requisition may say it is abandoned. This process has been abandoned because subsequently an advertisement has been made for direct recruitment to the post of account officer. And that advertisement your lordship will find page 40. Annexure F. Advertisement number so and so dated 12/12/14. The Assam State Corporation and Government of Assam Public Enterprise requires following personnel to be posted through its jurisdiction, including its subsidiary corporation, Assam State Urban Transport Corporation. Interested eligible Indian citizens may apply in prescribed application form as published in Assam Gazette number 2020. The post are account officer and internal auditor. So we were initially appointed as the internal auditor, Mike. So auditor, not the internal auditor. Then they were allowed to act as an account officer. Then these 7 posts, which the petitioner.
You are not allowed to act as account officer. You were divisional accountant.
Yeah, divisional account officer.
Now, this advertisement is for which post?
This has been made for the post of account officer. The
Account officer.
petitioners are agreed for the post of account officer.
Okay.
That which, my lord, they were directed to appear in the written test.
This post of accounts officer and accountant is the same.
No, it's a higher post.
These are higher posts.
This is a higher post.
You
the
need
scale-
to be a CA for that.
That is, they have said, man. And earlier it was not, man.
No, this is a different post, accounts officer.
My lord, that accountant, the petitioners were divisional accountant. They will be promoted to the account officer.
You said accountant. Let us see the expression.
But these two are, I
Let
think,
us- let us
same. It is
see-
accountant
let
and
us-
account officer.
Let us see the expression at page 29. 30.
It is decided to fill
Okay, accounts officer. Okay.
account officer.
Okay. Okay.
Account officer.
Now this.
So- So now they have gone for direct recruitment.
Okay.
So this has been challenged, man.
Okay.
There's all along there was no interview and seniority promotion was made on seniority basis. Only this is the claim only the petitioners. They should be promoted. And they also avoided to appear interview because earlier there was no interview in this post from promotion to the regional account officer, accountant to the account officer, man.
Now this posts have been filled up.
And now, that's of course, there is a field up. But this was, this advertisement was challenged at the relevant time.
Now what relief can you get?
If they are retrospectively treated to be the similar matter.
Now, if there was a stay order, these 7 posts were yet to be filled up. Matter would have been slightly different. Now, these posts have also been filled up. You had a claim that whether it's called accountant or accounts officer,
yes.
there was a earlier norm that persons in the cadre of feeder post of divisional accountant would be considered
Yes.
on the basis of seniority. It was tried to be filled up by a written test.
Yes, mate.
You did not appear, none appeared,
None.
it was abandoned. Then the process, a direct recruitment process was initiated. Now, even if you make out a case,
Yeah.
we interfere with this, what relief will you get? Nothing.
Relief is only if possible that day when these persons have been appointed.
Not in a case of this nature. In some cases, notional benefit, yes, if you are deprived. Now here, the process was initiated, you put to challenge in the year 2000 what?
14, my lord.
2014, 10 years have passed. Perhaps not a fit case where we can grant any relief. Mrs. Sayola.
My lord, they were given a chance, my lord, because earlier only one post was filled up, account officer. Now the STC revived, my lord, they wanted to fill up.
Now,
And-
first you tell us what is the mode of filling up the vacancy of accounts
There
officer?
No rule, my lord. No rule. That is why the board decided that there will be written test and interview and thereafter it fit up. Because if your lordship will see the affidavit, my lord,
No, the post
Yeah.
of accounts officer, is it to be filled up by direct recruitment or is it to be filled up by promotion
my
from the
lord,
existing?
there is no rule, my lord. They can be filled up by promotion as well as directly. Both. Both. My lord, here, my lord, what happened? They were given a chance. If your lordship see, nobody appeared, my lord, in the test. So what can be done, my lord? Ultimately, we are compelled to, my lord.
No, Mr. Sinha,
Yeah.
whether we go into that aspect or not, he's trying to make a case that in earlier period of time, this posts were filled up on the basis of seniority from the existing cadre of divisional accountant.
My lord, what I am submitting, my lord, earlier, my lord, that was help, my lord, because only one post was filled up. Because there were 8 posts, but they were not filled up. STC was in a very bad condition. Now, after some revival, my lord, they say that these 7 posts will be filled up. That is why, my lord, they decided that the competent officer, because the important, my lord, accounts officer, my lord, for the direct charter accountant is required. But they were given a chance, my lord.
Now, where these posts filled up?
Filled up by charter accountant, my lord.
Filled up.
All filled up, my lord. All charter accountants, the important, my lord, accounts.
Okay. Yes, please wait. 4 numbers of petitioners have joined together in filing this application under Article 226 of the Constitution of India, putting to challenge an advertisement published in the Assam Tribune in its issue dated 13/12/2014 by the ASTC for filling up 7 numbers of, amongst others, 7 numbers of posts of accounts officer. Full stop, para. The facts as projected is that the petitioners were working as divisional accountant in the ASTC, which is the feeder cadre, which according to the petitioner is the feeder cadre for the post of accounts officer. Full stop. A drive was initiated to fill up the vacant post of accounts officer, wherein the petitioners, along with other eligible candidates, were directed to appear in a written test, which was fixed on fixed on 31/7.
7:14.
31,
8:30.
yes, 31/7, 2020, 2014, consisting of two papers. Full stop. However, none of the candidates had participated in the said written examination, and the petitioners accordingly contend that the said process was abandoned. Full stop. The petitioners had also submitted a representation dated 7/7/2014, praying for consideration of their promotion on the basis of seniority. Full stop. However, comma, instead of considering the said representation, comma, the impugned advertisement was issued whereby seven numbers of post of accounts officer were to be filled up by direct recruitment, wherein the minimum educational qualification was also prescribed as chartered accountant. Full stop. Para. I have heard Sri Sinha, learned counsel for the petitioners, whereas, no, full stop. I have also heard Sri G.N. Sahewala, learned senior counsel, assisted by G. Duggal, learned counsel for the respondent ASTC. Full stop. Sri Sinha, the learned counsel for the petitioners, has submitted that on earlier occasions, comma, the post of accounts officer was filled up on the basis of promotion by taking into account the seniority of the candidates from the feeder cadre of divisional accountant. Full stop. The said process was, however, not adhered to, as initially a written test was sought to be held vide communication dated 30/6/2014. Full stop. The said attempt had also failed and stood abandoned, and therefore it was incumbent upon the corporation to consider the case of the petitioners for promotion on the basis of seniority in the feeder cadre. Full stop. The learned counsel for the petitioners has, however, informed this court that in the meantime, comma, the petitioners have retired from their service on attaining the age of superannuation. Full stop. Para. Per contra, comma, Sri Sahewala, the learned senior counsel for the corporation, has submitted that there were no rules prescribed for filling up the post of accounts officer. Full stop. Though an attempt was made by the corporation by trying to hold a written test amongst the in-house candidates in the cadre of divisional accountant, which includes the petitioners, comma, the petitioners did not or chose not to participate, and therefore he contends that due opportunity was granted to the petitioners for being selected for the said post. Full stop. It is further submitted that since the aforesaid process initiated vide the communication dated 30/6/2014 had failed to yield any results, comma, the post, the 7 numbers of post were filled up by direct recruitment, wherein the minimum qualification of chartered accountant was prescribed, taking into consideration the importance of the post. Full stop. He submits that that the financial health of the corporation at that stage was not very sound, and therefore the said process had to be adopted to fill up the post, full stop. It is all, full stop. He accordingly submits that no relief can be granted to the petitioners, full stop, para. The rival contentions have been duly considered and the materials placed before this court have been carefully examined, full stop, para. It is not in dispute that at the relevant point of time, there were no prescribed rules to fill up the post of accounts officer, full stop. Under such situation, comma, the concern of this court would be to examine as to whether the vacancies were filled up by a fair and transparent process, full stop. It also appears that initially an attempt was made to fill up the post of accounts officer by holding a written test from the in-house candidates in the cadre of divisional accountant vide the communication dated 36/2014, full stop. However, it is not in dispute that neither the petitioners nor any other candidates had appeared, and only on failure on the said process, comma, the corporation had adopted the recourse to fill up the vacant post, 7 vacant posts of accounts officer through direct recruitment, full stop. This court is of the opinion that the above recourse and the mode to fill up by direct recruitment from the open market cannot be faulted with, more so when there were admittedly no rules at that point of time to fill up such vacancies, full stop. This court has also considered the other aspect of the matter, that all the 4 petitioners have in the meantime superannuated from service, full stop. In the considered opinion of this court, comma, no relief, comma, whatsoever can be granted to the petitioners in this case, full stop. The writ petition accordingly stands dismissed. Item 2. Hmm?
That's your protocol. Perhaps get some other. Only last.
2015 matter.
Yes, my lord. Only for us today.
Hmm?
Only for today.
What is the matter about?
My lord, there was an advertisement in 2014. My lord,
For?
where 2014.
For
My lord, the
Various posts, my lord.
various
ONGC.
posts
in which in organization?
junior
ONGC?
technician.
ONGC.
Oh, yes.
Okay, then.
My lord, then my lord, prisoners appeared there. My lord, they were with district candidates below, my lord. All appointments were made. Some of the persons, my lord, with district candidates were also appointed. Then the list exhausted. We put another advertisement, my lord, for the next vacancies in 2015.
Hmm.
Now they have challenged the 2015 advertisement, saying that some posts, my lord, which are lying vacant, these are also advertised. My lord, in fact, it's not correct, my lord, because the registered candidates are all are exhausted, because in some posts, my lord, there are no candidates. Those are only advertised. So for business are concerned, these are not advertised.
Okay, day after tomorrow. day after tomorrow.
Chapter 30.
No, sorry. We don't adjourn matters of 15. On a special request, we are adjourning for a day after tomorrow. A prayer for adjournment has been made on behalf of the petitioners. Full stop. Considering that petitioners on the ground that the learned counsel is out of station, full stop, para. This court has reluctantly adjourned the matter and directs for listing on Thursday, 25. Yes, respondents,
The last occasion also they had not appeared.
yes. Okay,
But
start.
in this case, the petitioner was initially appointed as in the clerical post in the United Commercial Bank of India. And
Which
there-
bank?
Hello?
Which bank?
UCO Bank,
What did you say?
United Commercial,
That is not the bank. It's a UCO Bank.
yes,
You know why it's not United Commercial Bank?
why well,
You do not know. It was earlier United Commercial
Yeah.
Bank, not now. Why? Don't know. There is another bank of United Commercial Bank in Bangladesh. Now the name is UCO Bank, not United Commercial Bank. It's not a short form.
yes.
It's UCO.
But then,
You are what? How many of you are there?
well, only one.
What is it?
Well, the petitioner initially appointed as the clerical cadre member on 19/5/1983.
19?
1983. Then
Okay.
thereafter he was promoted to the cadre of junior management grade scale 1 on 1/2/1988
1 to
to 1988.
1988.
And thereafter, pursuant to a circular, he was participated in a promotional examination method,
Hmm.
and subsequently he was succeeded and promoted to the post of middle management grade scale 2 on 2/2/1999.
Middle management, grade 2.
Grade 2,
Hmm.
grade scale 2,
Hmm.
with effect from 19/12/1997. 12 1997.
Retrospective effect.
Yes.
2 years.
With respect.
Okay.
But surprisingly, after 20 months of such promotion, his promotion was withdrawn on 29/2000, which is that page 19,
2000.
2000.
Next year.
Yes,
After 1 year.
after 20 months,
Hmm?
because 2/2/1999.
Oh. 2000.
Yes,
After 1 year.
after 1 year, 10 months, 8 months. After 1 year, 8 months. Just February, 1 month, then 8
No, you said 2 to 99.
Yes,
2 or 29.
Yes,
2.
2
Oh,
to
oh, 2. Okay. 2nd February.
February.
Okay. Now it's 20th of September.
September.
Now a promotion has been withdrawn.
Which is that page 19.
19.
1. The reason that the criminal prosecution has been pending against the petition
Criminal prosecution.
by the CBI. Since the
Criminal case pending.
Yes, since the prosecution is pending against the petitioner, the aforementioned
By CBI.
CBI,
PC Act.
CBI, man.
PC Act.
Yes,
Prevention of
Yes,
Corruption
yes.
Act. Okay.
but
Yes.
in fact, my lord, at the time of promotion, this criminal proceeding was continued because So from the first institution of the criminal prosecution, the sanction was obtained from the bank authority. Despite that, he was promoted and subsequently after 20 months, he was withdrawn from such promotion.
You are contending that at the time of consideration for promotion,
Yes.
the same situation was existing.
yes.
In spite of that, you were promoted.
Yes.
So it cannot be a reason to again withdraw the
Withdraw
promotion.
the same.
It is not a subsequent development.
Yes, not.
Okay.
subsequent. Then, my lord, the petitioner submitted. a
When was the
request-
sanction given?
My lord,
When was the sanction
well,
given?
sanction date was not here, but which is reflected is that page, running page 84, my lord, of
The roundabout date, what is the
the date is not there.
approximately period?
Approximately, my lord, this was started in 2000, in 1999, my lord,
84.
84. My lord. The last paragraph, it may be mentioned that the case was filed against the Sri Samsul Islam and other employees by the CBI obtaining the due permission from the competent authority of the bank for prosecution.
Hmm. This is a communication of 14.
Yes.
So how can you relate? How do
Normal-
you substantiate your,
because the mentioning regarding the sanction of the prosecution against the petitioner was there in that letter.
no, in 2014,
In 2014 letter they have mentioned.
of which year? What is the period?
Well, the period, मतलब the
What is
during
9?
the period, मतलब 1991 to October 1992 is the judgment of the criminal case, मतलब that has been mentioned. The
Well,
period 1991
You were
to,
convicted,
no. Subsequently acquitted on merit.
acquitted.
On merit.
Was there a DP?
No,
No
DP
DP.
was not brought.
No DP.
No DP. Subsequently, मतलब what had happened,
Now, what was the one? When were you acquitted?
मतलब acquitted. Can you see the judgment is at page 25. The judgment on 15/7/2014
Oh.
and the relevant portion
Page.
page 25. This is the judgment and relevant portion is at page 43.
25 judgment dated. This is special case 103.
Yes.
One 103 of 04. 15/7/14. Special case 103. Okay, this is the
57,
judgment.
2004.
Where are you?
मतलब
What is your
relevant
name?
portion-
Your name is Samsul.
Yes, Samsul.
Petition.
The relevant portion is at page 43.
43.
40, the last paragraph. Under the facts and circumstances appearing in this case, I find and hold accused Sri Ranjan Sharma, Samsul Islam, Sri Bipin Chandra Sharma, Sri Rohit Rajput, Sri Bimal Datta, Sri Pranab Kumar Sharma not guilty under section so and so and section so and so. And I also find and hold accused Saleha Begum and Sharma not guilty under section so and so as the above accused person, namely Sri Ranjan Sharma, Samsul Islam, Sri Bipin Chandra Sharma, Sri Lohit Rajput, Sri Bimal Datta, Sri Pranab Kumar Sharma.
Acquitted. Okay.
Yes.
Then
Then the petitioner submitted a representation. And on that representation, subsequently, the impugn order has been passed, page 50.
when did you file representation?
The representation filed on 19/7/2014, page 45.
19/7/14.
Yes.
19/7.
Yes, 19/7/2014,
Page 40.
page 45. This is the detailed representation.
2 days after the judgment.
Yes, after that. Sir.
4 days after the judgment. Okay. You also forwarded a copy of the judgment, I think.
Yes.
Okay.
Then this impugned order has been passed on 25/5/2015,
Page.
page 50.
50.
50. The consequence upon your acquittal from charges by Honorable Special Justice CBI Assam, competent authority is pleased to restore your promotion from JMDS 1 to MMDS 2 nationally with effect from 19/12/1997 and to allow monetary benefits arising out of restoration of the above promotion to you from 22/5/2015.
Yes, what is the difficulty here?
But difficulty is that in the meanwhile, they have also kept Silkobar, decided to keep
No,
Silkobar by
no,
promotion.
what is the consequence of page 50? 50 is the order impugned.
Yes. In that portion of the restoration without any national as well as the monetary benefit.
No, with restoration notionally
Nationally, but
and to allow
the
monetary
period
benefits.
19/12/1997. In the meanwhile, during the pendency, they have kept the Silkobar his promotions. In the meanwhile, the juniors has already got promoted in the grade scale 5. So that has not been given. At least national promotion has to be given.
You have to be fitted. Fitment would be, you can get the fitment.
Because the decision of the Silkobar is at page 24.
24.
Yes. With reference to our journal office, Jorhat letter number so-and-so, where it has been advised by the competent authority in regard to your promotion to MMD scale 2 agenda. It has been decided by the competent authority that the promotion of Sri so-and-so may be treated as kept in Silkobar till he is completely exonerated of the charges by CBI. And in the meanwhile, he was already participated, my lord, in promotional examination, my lord, in the year 2001, 2004, 5.
What is the outcome of the Silkobar proceeding? Have they filed any affidavit?
They have filed, my lord,
In the Silkobar, what had happened?
but nothing has been stated in the affidavit. They simply said that the monetary benefit and other benefits cannot be given since he was not working in the promotional. That is their step.
No, that is one aspect. What
One
about
aspect, but the Silkobar, what happened, my lord, no details has been given in the affidavit.
these
Nothing.
promotions are on the basis of seniority?
Yes.
Only seniority?
Only seniority and examination also. Participation in the promotional examination, my lord.
You
And the
participated,
petitioner in the meanwhile participated.
and
in
your results were kept in
kept
Silkobar.
with her. But when his promotion was restored, my lord, that has been ignored. Because since his junior has already been promoted to the grade scale 4, and I have already annexed the gradation list, my lord, where his junior's name has been reflected. And I have made them party also, but we are not pressing against their. And their notification, my lord.
Let us read page 50 again.
Specifically, this has a reference to your appeal for restoration of your promotion from JMDS to MMDS 2 pertaining to the promotion process of the year 1997, the result of which was declared on 19/12/1997. Pursuant to that result, he was already promoted. Subsequently, with that, consequent upon your acquittal from charges by Honorable Special Judge CBI, Assam competent authorities pleased to restore your promotion from JMDS 1 to MMDS 2 nationally with effect from 19/12/1997 and to allow monetary benefits arising out of restoration of the above promotion to you from 22/5/2015. However, please note that your promotion is subject to the fact that you are not suffering from any disqualification on account of
That is
presence of-
okay. You have been given the notional benefit from the initial date when your promotion was given effect. That
Yes.
is 11/12 to 1997. and monetary benefit from 22/5/2015. 15. But
15.
you say that by this time when this order was passed
Yes.
from 97 or at least from 99 to 2015, 16 years have passed.
Yes.
And your contemporaries have been promoted in the meantime.
Yes,
Your case for promotion has not been considered.
that is the basic case. And also I have asked that if the monetary benefit he was not entitled at all, as per the notification and the judgment of the Janaki Raman, it's clear how his monetary benefit has
Have you
not
got
been.
Janaki Raman?
My lord?
Have you got Janaki
Yes,
Raman?
yes.
Which para? 8 or 18?
Para 26. my lord.
26.
Para 20.
Janaki Raman.
Para 26. We are therefore broadly in agreement with the finding of the tribunal that when an employee is completely exonerated, meaning thereby that he is not found blameworthy in the least and is not visited with the penalty even of censure, he has to be given the benefit to the salary of the higher post along with the other benefits from the date on which he would have normally been promoted but for the disciplinary criminal proceeding. However, there may be cases where the proceeding, whether disciplinary or criminal, are, for example, delayed at the instance of the employee, or the clearance in the disciplinary proceeding or acquittal in the criminal proceeding is with benefit of doubt, or on account of the non-ability of the evidence due to the act attributable to the employee, etc. In such circumstances, the concerned authorities must be vested with the power to decide whether the employee at all deserves any salary for the intervening period, and if he does, the extent to which he deserves it. Life being complex, it is not possible to anticipate and enumerate exhaustively all the circumstances under which such consideration may become necessary. To ignore, however, the circumstances when they exist and lay down an inflexible rule that in every case when an employee is exonerated in disciplinary criminal proceedings should be entitled to all salary for the intervening period is to undermine discipline in the administration and jeopardize public interest. We are therefore unable to agree with the tribunal that to deny the salary to an employee would in all circumstances be illegal. Well, therefore, we do not approve of the said last sentence in the first subparagraph after clause 3 of paragraph 3 of the said memorandum by, but no arrears of pay shall be payable to him for the period of national promotion preceding the date of actual promotion. We direct that in place of the said sentences, the following sentence be read in the memorandum. However, whether the officer concerned will be entitled to any arrears of pay for the period of national promotion preceding the date of actual promotion, and if so, to what extent, will be decided by the concerned authority by taking into consideration all the facts and circumstances of the disciplinary proceeding, criminal prosecution. Where the authority denies arrears of salary or part of it, it will record its decision for this. And the another judgment I have already given your lordship, which is
Sulek
yes,
Chand.
yes, ma'am. In paragraph 2, my lord, para 2, here in this also the situation, the criminal proceeding was drawn against the petitioner. These appeals arise from the order of Central Administrative Tribunal in OA number so the appellant was promoted from the post of ASI to SI, but he was confirmed with effect from
You are reading which paragraph?
para 2, my lord.
Paragraph 2.
Though it
Yes.
these appeals arise from the order of Central Administrative Tribunal in OA number so the appellant was promoted from the post of ASI to SI, but he was confirmed with effect from 4/1/1989. Though it was stated that this case for promotion had to be considered with effect from 1/10/1982. This claim was resisted by the respondents on the ground that in 1983.
You give your copy. You read from this copy.
Oh, sorry, man.
It is okay. Give that copy, we'll make it okay. You're in a hurry, it seems.
Yes.
Okay.
These appeals arise from the order of the Central Administrative Tribunal in OA number so and so. The appellant was promoted from the post of ASI to ASI, but he was confirmed with effect from 4/1/1989. Though it was stated that his case for promotion had to be considered with effect from 1/10/1982.
It is okay. Janaki Raman is very clear.
Is very clear, my lord, but in the
Even
last
for
post of,
even for the purpose of or the aspect of the notion, the monetary benefit, they'll have to take a call.
Yes.
In your case, there was no DP, number
Yes.
one. They have in principle given you the
yes,
whatever benefits. The interregnum, the promotions, they have done nothing.
Nothing.
There is on record that they have kept in seal cover. They have not disclosed what has happened
Yes.
thereafter.
and in the meantime, the petitioner already regularly participated in the promotional,
When did you
Definitely.
participate?
my lord,
What time did you participate in the promotion?
my lord,
exercise?
para 11, my lord, I have stated. Para 11, page 7. Para 11, page 7. That the petitioner stated that subsequently the petitioner again submitted another representation so and so. By saying the petitioner participated, applied for participation in minimum 6 number of promotion process. So far, since the date of withdrawal of his promotion, and out of this, he was not invited in the year 2002, 2004, and 2007.
7,
and the-
11, just a minute. Let us have a look at the pleadings. 7, 11. Six, on 6 occasions you participated and 3
Three
occasions
occasion he was not
you're not invited.
and others are not communicated.
Was any appeal preferred against the acquittal order?
No, madam, no. In that case, my lord, my humble submission before your lordship, since all the no fault for the petitioner, my lord, this promotion could not be done, my lord. He is willing to work in the promotional post, but due to the interference of the authority, my lord, he could not work in the promotional post. That's why, my lord, my humble submission before your lordship, since the petitioner has already been retired, who retired on, my lord, 31/8/2019. From
And
the-
so far as the monetary benefit is concerned, even they have not worked out. Have they worked out as per Janaki Raman?
No, but
They have-
nothing has been done. Even they have annexed in the affidavit in opposition, their notification. Said
They-
like that, my lord, said Janaki Raman, but that has also not. In their affidavit, my lord, can we see page the page 77 running page, my lord.
77, yes.
Yes. Close to
Hmm.
at the time of consideration of the cases, the
Hmm.
government servant for promotion, details of the government servant in the consideration zone for promotion falling under the following category should be specifically brought to the notice of the departmental promotion committee. Government, that is the 3 number is applicable in the petitioner's case. Government servant in respect
Yes.
of whom
Well, sorry, but that matter was earlier represented by Mr. Nikul Barwa. He is not in panel right now in the bank. Bank has informed me this morning only, but I'm not able to, I have checked before another court. Not if a small accommodation.
We've heard Mr. Islam. We'll hear you tomorrow then. Tomorrow. If you want, you can get a copy from Mr. Islam, or you want assistance of the court's record, you can have an inspection.
Sir, but that be day after. Because I
Okay,
have to
day
collect the
after.
copy also.
Day after tomorrow, but not thereafter.
Yes, sir.
We had given opportunity on the last occasion. What was the bank
Yes.
doing?
Still not the, because of this Nitul Barwa, the retired counsel, he is not appearing in the case from so many days. That is why the matter has been
Okay, day after tomorrow. Oh. Heard.
highly affected.
3R Islam Learned Counsel for the petitioner at some length. Full stop. Though initially there was no representation from the respondent UCO Bank, during the course of the hearing, Sri M. Sharma, Learned Counsel, has appeared and submitted that he has been instructed to represent the bank, as the earlier counsel is not appearing. What's the para? In the interest of justice, a short accommodation is granted. He prays for a short accommodation. Para, in the interest of justice, a short accommodation is granted, directing listing of this matter on 25/4/2024.
Highly
Matlab.
There is not, I don't think there is much to dispute. You take instructions.
Yes, sir.
He is also retired.
Yes.
Wait, the senior is appearing through video conference.
Hmm?
The senior is appearing through video conference.
Okay. Yes, Mr. Kaur, where are you?
In Delhi, my lord.
Okay.
May it please your lordship, my lord. My lord, this is the second round of litigation so far the petitioner is concerned.
Who's for the respondent? You.
My lord. My lord, we all know that transfer is an incident of common service. But sometimes we come before this honorable court when we see that the transfer orders are not in violation, is in violation of the notifications and the rules. If your lordship will see, the last order passed by this honorable court is at page
Page.
47. Well, basically, the last order was to directing us to file a representation before the authorities, and the authorities will take into consideration the grievance of the petitioner, my lord. Now, so far the petitioner is concerned, my lord, he is going to retire on 31/2/2025. That means hardly 9 months as remaining. 31/2/2025.
Let us read the order at page 47.
Yes, my lord.
I think everything.
It's a
will be
short
clear.
order.
The facts would be clear. Please read.
Yes, my lord. The grievance of the petitioner is the order of transfer dated 28/2/2024, which was issued to the petitioner, transferring the petitioner from his present place of posting to Kamrup Metro. This order came to be modified by subsequent order, which is annexed to the petition, being order dated 15/3/2024, from where he was shown to be transferred to the office of the Deputy Commissioner Nalbari in place of Deputy Commissioner Kamrup Metro. The learned counsel for the petitioner submit that if this transfer order was indeed issued under the ECI guidelines, that the same appeared to be in conflict with the ECI guideline itself, as the new place of posting is Barpeta.
Just a minute, we not very. For the grievance of the petitioner is the order of transfer of 28/2/24,
Yes, madam.
which was issued to the petition transferring the petitioner from his present place of posting to Kamrup Metro. What post was he holding?
But he is presently holding the post of SDO in Kamrup district, not Kamrup Metro. This order never came into effect because your lordship will read the
He is
subsequent
an
order.
SDO civil.
Yes, but he is not entrusted with any election duties.
No, that
So
is
they-
okay. No,
that-
no.
yeah.
This order of 28/2/2024 had transferred him from where to where?
My lord, from Kamrup to Kamrup Metro. But it was never given effect to. My lord, there are two orders we are challenged. One is the order dated 28/2/2024 and the other is 15/3/2024.
15-3 is the second order.
Yes, my lord. Where he was transferred to the office of the Deputy Commissioner, Nalbari, my lord.
20,
15/3/2024.
15-3,
Yes, my lord.
transferred to
Nalbari.
DC office, Nalbari. Okay.
Yes.
Then,
Then your lordship will see the paragraph number 3 of the order kindly.
yes,
The learned counsel for the petitioner submit that if this transfer order was indeed issued under the ECI guidelines, that the same appeared to be in conflict with the ECI guidelines itself, as new place of posting in Borpeta is the parent electoral district of the petitioner. That apart, by communication dated 23/2/2024 issued by the Deputy Commissioner Kamrup Aminggaon, no duties are shown to be entrusted to the present petitioner as against the duties entrusted to other officers mentioned in the order. The learned counsel for the petitioner submit that he is retiring within 9 months. But that date of retirement is 31/2/2025.
correct.
And therefore, at this stage, transferring the petitioner in conflict with the ECI guidelines, and that too without allotting any electoral duty, does not satisfy the requirement of law as prescribed under the ECI guidelines. It is evident that orders have been issued without proper appreciation of fact and without due application of mind. He therefore submits that this impugned orders be interfered with and set aside. Mr. T. Shutia, learned additional senior government advocate, on the other hand, submits that the transfer is issued in terms of the ECI guidelines and the petitioner is not covered under the exemption under the ECI guideline, as he is retiring within 9 months. Your lordship will kindly take note with it how they deal this paragraph in their representation, my lord. Therefore, the authorities concerned considered it appropriate to have the petitioner transferred because of the ensuing election. He however submits that the petitioner may approach the authorities by filing a representation, and the competent authority will examine and pass necessary order. So basically, the representation was filed, and that the speaking order your lordship will find in page 52.
5-2.
5-2. Now, in the middle portion, your lordship will find how they have dealt it with this issue. So, paragraph 1 is not very, paragraph 1 of that, whereas on examination of the matter, the following findings are recorded. This is not very relevant. Your lordship will look at paragraph number 2.
What is the date?
Well, this was disposed of on,
Is it 15-4 or 19-4?
just let me check at the bottom, my lord. It's looks like
13/4/2024.
13-4.
13-4. It's so your lordship will see how this representation has been dealt with. Whereas on examination of the matter from the middle portion, your lordship will find the following findings are recorded.
Yes.
ECI had released the instruction dated 21/12/2023 for transfer of officials directly connected with elections who are either posted in home district or who have completed more than 3 years of service in the same place of posting. Further, clause 5 of the ECI instructions stipulated that the instruction shall cover not only officers appointed for specific elected duties like so-and-so, so-and-so. The officers of Assam Planning under this department in the cadres of assistant development officers or senior development posted are engaged in the election duties and various roles by the respective district election officers as and when required. Therefore, department prepared a list of all such officers who would fulfill either of the two conditions mentioned above and issued transfer posting notification dated so and so. Hence, the transfer orders are not in contravention. He does not explain. He just said that it is not in. So he says that these are not in contravention. But how he dealt with, your lordship will find it at the bottom. The ECI-wide communication dated 23/2/2024 had stipulated that all states shall ensure that officers who are transferred out of district are not posted within the same parliamentary constitution. However, later on ECI-wide communication number so-and-so, so-and-so, and so-and-so. Now your lordship will see the sub-para, Sri Moral. Sri Moral was not engaged in election duty. So this election notification will not be applicable because I have not been entrusted with the election duty. Now the next question remains is that earlier in my office records, my home district was shown as Kamrup because I belong to Hosai. But after this delimitation exercise, now Haju has fall under Nalbari. So if I'm transferred to Nalbari, it will be my home district. They say that in the record, my home district is Kamrup, but I have enclosed my voter list to show that now after this delimitation exercise is Nalbari, so it is non-application of mine, my lord. Hence, the ECI guidelines of posting of officer outside was not applicable to Sri B.C. Moral. Moreover, as per record available in this department, the home district of Sri Moral is Kamrup and not Nalbari. Hence, Sri Moral was posted in Nalbari, and this is in conformity. This is completely non-appreciation of material, my lord, which was placed, my lord, because I have annexed my voter list to show that I belong to the Nalbari district parliamentary constituency.
Where is
now.
your voter list?
My lord, your lordship will find my
Haju is not
voter.
a part of Kamrup now.
Now, Haju has been merged with Nalbari now.
Parliamentary constituency.
Yes, my lord.
There are
My
six.
page 40.
Oh. It's 40 no?
Yes. It starts from 40. I have given the type copy. Your lordship will find.
Now, where is the restriction
Oh.
regarding the constituency?
That constituency, my lord, it has not.
Parliamentary
Yes, my lord, there is a ECI
Okay.
notification.
Now you are referring to page 40 what?
41.
41.
Sorry. My lord, it will be Borpeta. Now it is, I think, Hongrekon Statiti, Borpeta Hadron. It's not Nalbari, Borpeta Hadron. I'm sorry. It will be Borpeta Hadron. So, but even otherwise, they say that I have been transferred from Kamrup to Nalbari because my home district is shown as Kamrup. But it appears from the voter list at page 41. At the top, your lordship will find that Borpeta Hadron.
Where? Page 41?
41 voter Bidhanabha Homosti, Kun Hongatia Homosti, Ontagata Tar Nam or Hongrakya Steti, Tini Borpeta Hadron. Second line, my lord.
Yes, Borpeta Hadron.
So, so this
Okay. Number 30 Hajar, Falgusi, Jati. You are contending that your parliamentary constituency
is Borpeta.
nothing to do with Kamrup.
Yes, madam. And I have not been entrusted with any election duties. Even if election duties is also entrusted, it is only applicable in case of EO and AOR, not the other subordinate officers, madam. So this observation in the speaking order, my lord, is without application of proper mind, my lord.
Yes.
Now your lordship will also see page 53. My lord, in the ECI instruction, that page 53, paragraph number 3, in the ECI instruction dated 21/12/2023, it was stipulated that the officers whose retirement was due within the next 6 months were exempted from the transfer posting guidelines. This 6 months period was to be reckoned backwards from 30th June 2024. However, in the case of Sri B.C. Moral, there was a time frame of 9 months to his retirement. We admit, my lord, that there is a time frame of 9 months. But when we have retirement for 6 months, the court says that you consider it, is this not a case where a sympathetic consideration of the government is required? Since I have already 9 months to retire, why displace me now? Then paragraph number 4, my lord, it talks about my frequent transfer. They said that it is only change of designation by promotion and all. So you cannot say that it is transfer. It is only it's in you are in the same post. But with that post, the responsibility also changes. The nature of duties changes, my lord. So that's my humble prayer that since my posting at Kamrup has nothing to do with my election duties, and this Kamrup is not my home district, so if only my transfer to Nalbari is interfered by this honorable court, my lord, it will not cause prejudice to them anyway. And I have served this department for my entire life. I have never asked for any modification of this transfer orders. My lord, this is the time, my lord, when I first came before this honorable
Okay,
court.
yes, yes, Mr. Dhar.
When this matter was considered, my lord, we have gone by the record. So, my lord, if you go by page 53, his home district is, my lord, Kamrup. That is by the record, my lord. So, if you go by the guideline, my lord, officer, we cannot keep him in his home district. We have transferred.
So what is the requirement of the guidelines? Earlier page. For transfer.
My lord, I start from top, my lord. The order, my lord, page 50. Whereas PC Moral Senior Development Officer was transferred from Kamrup to Kamrup Metro. That is the initial transfer, my lord, by this department's notification dated 22/24 and supplementally to Nalbari by this department's notification dated 15/3/24. Yes, for transfer posting guidelines issued by the Election Commission of India with the approval of the competent authority in view of being Lok Sabha election 2024 in the interest of public. So, my lord, basically we have done it. It's not by the department, my lord. In a transfer posting during election, my lord, we send it. Initially, Election Commission, they ask for us a list of all the officers, their home district, how long they have been serving in the thing. So, my lord, accordingly, from the record, my lord, we prepare a list of all the officers in the district and we send it to the Election Commission. Then, my lord, it is by their, my lord, initiative, we just transfer them so that, my lord, basically, my lord, why we transfer officer from?
No, see, Mr. Dhar, there would be a distinction between a home district and a parliamentary constituency.
Right.
Hajo district, I think it's still Kamrup. But as a parliamentary constituency, it becomes a part of Borpeta, is it
My
correct?
lord, that is the catch here, my lord.
Yeah.
I'm coming there. Why this parliamentary constituency? This is regarding, I'm coming there, my lord. But home district and parliamentary constituency, these are two different aspects.
Different
my lord.
aspects.
Very different aspect, man. Home district, I can influence. I am a son of the soil. I come from the city. I know at least 5 people. I may influence this vote. I being a government of
But
that is the
that Hajo is a part of Kamrup is not disputed.
not dispute. It's a home district.
Home district. So he comes, even if we leave aside the aspect of parliamentary constituency, which may be Borpeta,
Borpeta,
but he comes within the this mischief of home district.
home district.
So he needs
So
been.
he needs to be. We have
But what about the retirement part? He's going to retire in 9 months.
my lord. That is not part, my lord. Election Commission says 6 months.
It is
Election-
okay. No,
My lord, that is the guideline. If we go by the guideline, my lord, that is Election Commission's guideline is 6 months, not beyond that. He is in 9 months. And that part also, my lord, we have to take into consideration, my lord. Law is equal for all, my lord. Here, my lord, he is an officer in the rank of SDO, and that is his home district. And Election Commission says, well, that anybody, my lord, who falls in this parameter has to be transferred back. That is why we have done, my lord. This is not that we have picked him up. No, it is by the direction of the Election Commission of India, we have done it, my lord. And it has happened to everybody. Those who are from home district, they have to move out. Every, my lord, 3 years is happening, my lord, in election. Either way, my lord, in parliamentary election or, my lord, ML election. That is the, my lord.
No, is the guidelines regarding the retirement part, home district part, no problem.
My lord, guidelines
Home
here, my lord,
district,
here,
home district is still covered because parliamentary constituency will not make any difference.
any different.
His home district is Hojai. Hojai is a part of Kamrup. He
Hajo,
is
my lord.
shunted from Kamrup.
Kamrup.
But the retirement aspect,
Retirement aspect, my lord,
is it such a inflexible kind of?
my lord, during election, it is my lord, it's an election time. Even if my lord, I'm not saying that he may, but my lord, generally it is taken that, my lord, if I may even influence one vote, I even, my lord, it will go against the mandate, my lord.
My lord, with your lordship's permission, may I
No, we'll come to
interfere?
you.
Yes, ma'am.
We'll come.
Your
to you.
lordship will find a
My lord,
guideline
We'll
and
come
please.
to you.
Yes.
We'll come to you after finishing.
that is why, my lord, it is election commission always, my lord, to be make a very fair and transparent election process. Election commission does.
No, so far as the steps the election commission is taking, we have nothing to comment on that, but that cannot be a hard and fast rule that only because you are out of the home district, you cannot influence a voter. Those are not acceptable. You can still influence a voter. You who work in Hailakandi, can't you influence a voter in Kamrup?
But still, my lord.
No,
I
it
will
is
have a
okay. It is
bigger
okay. It
advantage
is
in
at
my
least
home state.
at least some tangible action you take.
Yes.
That to ensure that
And
fairness
ensure
is
that,
done.
my lord,
That is
there is
okay.
a
We are,
transparent
we are not
and-
commenting on that.
And my lord, this is equal to all, man. All the officers are facing this. It's not only that he has faced, and this is not done by the state, man. Once this election commission comes into court, my lord, this model code of conduct comes court, they are the one, my lord, who takes call on everything, man. Government, my lord, doesn't matter.
Okay. Yes, Mr.
My lord, my learned friend may also look at page 31, my lord. Your lordship will find the ECI's guidelines, my lord.
3-1.
3-1, my lord.
Yes.
Paragraph number 3, your lordship. Hence, the commission has decided that no officer connected directly with elections. They have themselves admitted that I am not connected with elections. So these guidelines that no officer connected directly with elections shall be allowed to continue in the present district revenue district of posting if she or he is posted in his or her or his home district. So they have themselves admitted that no election duty has been entrusted. So these guidelines of my home district will not be applicable so far ECS guidelines is concerned, my lord. And second one also
I
will
think
not
there's
be
a
applicable.
There is a reference in the impugned order that you are not connected.
Yes, and there is also an order of the separate order showing that I am not
Not engaged.
not engaged in election. That is not disputed, my lord.
Yes, yes.
And even the second clause will also not be applicable. That if she or he has completed 3 years in the district, during last 4 years, that chart your lordship will find at paragraph number 17 of my writ petition. 16, my lord. I'm sorry, at page 17.
Yes.
So I was DC Kamrup, the 10 months, 9 months, and now I have been transferred. So this second clause will also not be applicable, and these are not be applicable because even otherwise this will be applicable only if I'm entrusted with election duties. So I have not been entrusted with election duty. That is not disputed.
No officer connected directly with the elections. Yes, that is one more catch you have to.
My lord will come to page 52 once again.
Yes,
I could not
53. Come
wait.
to 53. The sub paragraph after.
No, my lord, I will start from 52, my lord.
Okay.
It's the last part that I have to read.
Yes.
Bottom, my lord.
Yes.
Just point to my lord. Cross to the ECI by communication certain such dated 23 to 24 had stipulated that all states shall ensure that officers who were transferred out of the district are not posted within the same parliamentary constituency. However, later on ECI by communication dated such and such 27 to 24 clarified that ECI instruction dated such and such would be applicable only to DEO, Deputy DEO, RO, AROs, and rank of this police officers, my lord, up to the circle officer or equivalent rank. So, my lord, this is only to them. Now, next I continue. Sri Moral was not engaged in election duty in the role of these officers above mentioned, my lord. Hence, the ECI guidelines of posting of officers outside parliamentary constituency. The upper thing is only for parliamentary constituency, my lord, not for home district. Constituency was not applicable to PC Moral. Moreover, as per records available in the department, the home district, we, my lord, harp on home district, my lord. Home district of Sri Moral is Kamrup and not Nolbari. That is why he has been transferred to Nolbari. Hence, Sri Moral was posted in Nolbari. This is in conformity with the ECI guideline. So, my lord, that part would not apply to him. only the home district.
No, but the main guidelines, which is at page 31, Mr.
Fine.
Kumar has referred.
Fine.
Serial number 3.
Fine.
The commission has decided that no officer connected directly with the elections shall be allowed to continue in the present district, revenue district, or posting if he is posted in her home district.
My lord, that is of 23, my lord.
Yes.
And this notification is dated 21/12/23.
Yes. That is
If
the
you're-
notification you are taking into account.
And now, my lord, we are taking into account 23 to 24. That
Yes.
is what ECI in page 52 says, my lord.
Same parliamentary constituency will not arise. Because if you come into consideration of same, it's two different aspects. One is home district. Home district, he has to be connected to election duties. He is not. Then the second notification 24 is with regard to parliamentary constituency. The parliamentary constituency is not the same.
My lord, parliamentary constituency, in parliamentary constituency, my lord, if he is in election duty.
He is not the same. It's not the parliamentary constituency. It's a different parliamentary constituency.
Nalbari is a different.
Yes.
Yes, so that is why we have standing there.
No. His place of residence is Hajo, which is a part of Borbeta constituency. So he working here will not.
But his home district is, my lord,
Home district, he has to be connected with election duties.
no, my lord, where it says, my lord.
Page 31.
And if your lordship looks at page 39, it is clearly mentioned that I have not been
31?
entrusted. 39
Yes.
also, your lordship will find that I have not been assigned with election duties.
No officer connected directly with election shall be allowed to continue in the present district. My lord, it says, my lord, I'm just reading. The commission, no officer connected directly with election shall be allowed to continue in the present district. Connected with election duty, my lord.
Yes.
He is not connected.
Yes.
So, my lord, he can go.
He will not be allowed if he is directly connected. He is not connected.
My lord, that is one aspect. But
You have not understood properly. See, really
No.
properly. Hence, the commission has decided that no officer connected directly with the election shall be allowed to so and so if he is posted in the home district. If an officer connected with election duties is in the home district, he'll not be allowed to continue. That is-
Exactly, my lord.
Yes.
So how this helps him, my lord? He is not in election duty.
He is not in election duty, so this will
Exactly.
not be applicable here to him. The contention that one officer will not be allowed to continue if he is connected. He is not connected to election duties.
He is not connected to election duty, but he is in home district. That part has
So
to.
that restriction comes only one is connected with the election duties and is in the home district.
No, my
Why
lord.
no?
No, my lord. Suppose my home district is Golaghat.
Yes.
I have been here for 3 years,
Yes,
my lord.
yes.
I have to go.
That if you are not connected with see, there are 3 points. First, hence the commission has decided that no officer directly connected with the election shall be allowed to continue in the present district of posting if he is posted in his home district. They restrict the example which you had given that you are from Golaghat, you are working here. That is not a part of this. This will be only for officers who are at their home district and connected with election works.
If she,
And the other aspect that your whole district is somewhere else and you're working in some other place, then the restriction will come that whether you have completed 3 years during the last 4 years. Okay.
And even if your lordship looks at page 39, your lordship will find that I have not been entrusted with election duties.
Okay, heard Sri B.D. Kaur, Learned Senior Counsel for the petitioner, assisted by
SK,
petitioner who has appeared online and is assisted by Ms. S. Jain.
SK.
Full stop. Also heard, the petitioner has put to challenge an order dated 13/4/2024 issued by the Department of Transformation and Development, Government of Assam, by which the representation of the petitioner submitted regarding his transfer from Kamrup to Nalbari has been rejected. Full stop. The petitioner, who is a senior development officer working in the district of Kamrup, was initially transferred from Kamrup to Kamrup M vide an order dated 28/2/2024. Full stop. The said order was subsequently modified vide an order dated 15/3/2024, whereby the petitioner was transferred to the office of the Deputy Commissioner, Nalbari. Full stop. The petitioner, having failed to get his grievances redressed by filing a representation, had earlier approached this court in WPC 1627 of 2024. Full stop. This court, vide order dated 8/4/2024, had directed for consideration of the representation, and till such consideration, the impugned orders of transfer were stayed. Full stop. Para. Required the learned senior counsel has submitted that the impugned order dated 13/4/2024 has been passed without any application of mind and by a wrong interpretation of the guidelines of the Election Commission of India pertaining to transfer. Full stop. It is submitted that the petitioner is admittedly not connected with any election duties, and though his home district would be Kamrup, as he is a permanent resident of Hajo, the guidelines issued by communication dated 21/12/2023 would not be applicable. Full stop. As regards the other aspect which appears from the subsequent guidelines dated 23/2/2024, the learned senior counsel has submitted that the petitioner, that the parliamentary constituency of the petitioner is not Kamrup but Borpeta, and therefore there was no occasion for application of the said guidelines. Full stop. In this connection, the learned, attention of this court has been drawn to the document at page that Kamrup part,
40.
Borpeta part,
Page 40, annexure 10.
document at annexure 10, as
Yes,
per
page
which the petitioner has been, as per which the parliamentary constituency of the petitioner has been shown to be Borpeta, within bracket general. What is this general?
Just like the reserved
Oh, general,
constituency.
okay. Okay. General, full stop. Para. Sri R. Dhar, learned State Council, however, submits that there is no malafide involved in the transfer, and it is done as per the guideline, but it is done by following the guidelines of the ECI. Full stop. He submits that as an exercise to be conducted prior to the elections, list of officers were sent to the ECI, and by following the guidelines dated 21/12/2023 and 23/2/2024, transfer has been made. Full stop. Para. Let notice be issued. Returnable on returnable on, 10th of, on 13th of May, 2024. Sri Dhar, the Learned State Council accepts notice on behalf of respondent numbers 1 to 7. So let extra copies be served upon him, no? By tomorrow. Let steps be taken for service of notice upon the respondent numbers 8 and 9 by registered post to TD, steps by tomorrow. Third, the Learned Council on the interim prayer, full stop. Prima facie, this court is of the opinion that the interpretation found in the impugned order dated 13/4/2024, qua the instructions dated 21/12/2023 and 23/2/2024 of the ECI is not correct, may not be correct, is not correct, full stop. It is the impugned order itself states that the petitioner is not engaged in any election duty, and the materials on record also reflects that the parliamentary constituency of the petitioner is not Kamrup but Borpeta, full stop. In view of the above, till the returnable date, the impugned order.
My lord, Annexure 7 and 8. The transfer orders.
The impugned transfer, the impugned order dated 12/4/2024 is stayed, full stop. Consequently, the transfer order dated 15/3/2024 also would also remain stayed.
My lord, the first transfer order will be 28/2/2024.
Also, consequently, the impugned transfer orders dated, 28/2 has been modified. Where is bordered?
Yes, madam. But they may again reactivate that. That's it.
Kamrup to Kamrup M will be very happy.
Okay, my lord.
Or is Hajo, Amingao closer to Hajo? Why the private respondents?
Well, they have already been adjusted, but still it is a,
No,
if I don't make
it was a by-way transfer or two-way
Yes.
transfer.
It was
anybody
modified.
affected?
Hmm.
Let us see the
Well-
impugned order of transfer.
My lord, your lordship will find the first, the modified transfer order is at page.
Okay. Still.
We are deeply obliged, my lord.
Yes, next.
I have been anticipating on the previous,
What is the matter, madam?
Promotion matter, my lord,
Promotion.
yes. From the grade D senior manager molecular to grade D. There has been some department promotion committee report, my lord, which has to be obtained through RTI.
Now, is there any live cause of action now?
Not that
So what is the matter?
But I've just been head over the. That I paper that is signed
18 matter.
7 days, my lord. Today only I have got.
You take the brief of the court day after tomorrow. 18 matter we are not adjourning. Only because you said that you are
Today only I have.
appearing for the first time, we are giving you 2 days time. Okay, Thursday.
Let it be on 30.
Your Mbora,
B board.
B Bora, you're not there.
I'm
Heard MSB Bora, Learned Counsel for the petitioner. Full stop. You file local, Master Lord?
Today.
Okay. Sri Edhar, learned counsel, has submitted that he has filed the wakalatnama on behalf of the respondents today. And according to praise for some accommodation, full stop para. Considering the above position and also the aspect that the case is of the year 2018, a slight accommodation is granted, directing listing of this matter on 23rd, Tuesday, or not, 30,
Apply.
30, 34. Tuesday.
Apply.
Item 5. Records are there, madam? When is Mr. Sharma coming back?
Let me just take time.
Today, then we'll have it
Whatever.
tomorrow or day after? No, is he out of station?
Yeah.
When is he coming back?
I'm not aware of it, but he has asked me to keep convenient.
No, no, 30th,
Tuesday.
this court is not very sure whether it'll be there or not. Today is 23rd. We'll have it on Friday. Friday. Okay, bring the records. Okay. Okay. No, you retain the records. Okay. A prayer for adjournment has been made on behalf of Sri M. Sharma, learned counsel for the petitioner, who is stated to be out of station. Full stop. This court, the matter was heard at length by this court on 4/4/2024. After which, the records were directed to be produced. Full stop. Ms. R. Kakoti, learned counsel, appearing for the respondent numbers 1, 2, and 3, has submitted that the concerned records have been produced. Full stop. Sri D.K. Bhattacharya, learned counsel, appears for the, is present for the respondent number 4. Full stop para. In the interest of justice, the matter is adjourned to be listed on Friday. Item 6.
Kindly Firuz, last order dated 12/3.
12?
Three.
Yes. Yes, paid or not?
No, Lord,
Nothing has been paid.
There is a release order.
but not paid, Lordship. Today morning, my inspection is not paid.
Release order of which date?
5/4, Lord. Just not.
5/4.
Please pick it up.
Wait for some time. Okay. Heard Ms. P. Bhattacharya, learned counsel for the petitioner, who by referring to the earlier order dated 12/3/2024 has submitted that the pension amount after the deduction of the house rent was directed to be calculated and paid, which has not been done. Full stop para. Your name?
A guy,
A. Gayan.
on behalf of PK.
Okay, Sri A. Gayan, learned counsel, appearing on instruction of Sri P.K. Munir, learned standing counsel, Assam Khadi and Village Industries Board, has however placed on record a communication dated 5/4/2024, as per which the post-retirement benefits has been released. Full stop para. In view of the aforesaid development, the release, full stop. He further submits that within a short period of time, the amount would be credited in the account of the petitioner, full stop, para. In view of the aforesaid submission, comma, the matter is adjourned to be listed on 10th of May, on which date the up-to-date status may be apprised by the learned council. Para, copy of the statement dated 5/4/2024 is made part of the records.
My lord, this is the petition, my lord, by three employees of the Promoter Valley Fertilizer Corporation Limited. Earlier it was Hindustan Fertilizer Corporation Limited, Parsa. My lord, to only come to Annexure 1, page 17-18. While annexing the list of sanctioned post, my lord, which is at 18, is further to our select number showing dated
You are at page 18,
page 17 first, my lord.
17. What is
That
17?
is just a forwarding letter, my lord. Further to our telex number showing dated 16/9/1991.
Now, who are you? You are?
We are the teachers in higher secondary school in Paramutra Valley Fertilizer Corporation
How
Limited.
many of you are there?
Three.
Three petitioners.
Hello?
Three petitioners.
Yes.
What do you do?
We are teaching in higher secondary school.
Teachers.
Yes.
Teachers where?
Paramutra Valley. Earlier we are in the Hindustan Fertilizer Corporation Limited. SFCL. Now we are PBCL.
Now?
Paramutra Valley Fertilizer Corporation Limited. Same organization, just transposed. Name is transposed.
Brahmaputra Valley Fertilizer Corporation Limited.
Yes. Let's only come to page 17 first.
17, yes.
Further to our telex number showing so date is 16/9/1991, OM number showing so date is 17/9/1991. Includes, please find the summary of the revised sanction post. This is important, my lord. Because unless the posts are sanctioned, my lord, we have no right to be regulated.
No, your job
Yes.
as teachers
Yes.
were under the corporation.
Yes, it is a corporation school.
The school was run by the
Yes,
corporation.
corporation.
Okay,
Generally, there should be Hindustan Kendriya Vidyalaya, Madhur,
correct.
but now it is been running since then.
Okay, what is the name of the school?
PBCL SS school.
Okay, by the name of the corporation itself.
Yes, yes.
Okay. Now this is sanctioning summary of revised sanction of post.
Yes. There is of 1991. That is of 1991.
Oh,
Now next page 100, page 18. The lots will come.
18, yes.
Yes. School. As the lots word
Yes, yes.
school.
Hmm.
There are 117 posts of teachers in school. Well, principal 1, vice principal 2, headmaster 3, teachers SS 170.
Yes.
These are sanction posts.
Hmm.
Revised sanction. Your lots will make
Yes.
it at the fourth column of the top.
Yes.
This is important for my lord. Then you also kindly come to our appointment letters. Annexure 2 onwards, page 19 to 24. Page
Yes.
19. We were enrolled in the employment exchange, my lord, and through employment exchange, the applications were called by the Hindustan Fertilizer Corporation Limited, my lord, and the employment exchange is also known as 76 Act. Under 1976 Act, it was compulsory.
This was prior to your appointment.
My lord,
Exercise prior to your appointment.
prior to my our appointment.
This is how you
Yes,
were
we
inducted in the
got
service.
entry, yes.
Your name was forwarded by the employment exchange.
Yes.
Okay.
Because during that time, paper publication was
No,
not
that is
much
okay,
low.
okay.
Even I got 5 jobs only in 5 years, including Bank, State Bank of India. We were all enrolled in, and one after I went and resigned, again enrolled, and again got. So that is that was the procedure manner. The Employment Exchange Compulsory Notification of Vacancies Act 1959.
Hmm.
So under that manner, there is a provision manner that you cannot appoint anybody not to apply in section 3 manner, not to apply in relation to vacancies. This act shall not apply in relation to vacancies in any employment, the total duration of which is less than 3 months. Here we are given 40 days appointment. And for last 30 days, 30 years we are continuing. For last 30 years. This is the employment exchange manner. Here we are called. Pranjal Datta is the number 1 petitioner manner. Framing panel of adult teachers, some demonstrator, physics, chemistry. Yes, ma'am. The employment exchange Namru has sponsored a name for the above mentioned post. You are hereby requested to appear for an interview before our selection committee on 2/12/1993 at 8:30 a.m. in the office of the administrative building
Yes,
of the
yes,
Hindustan
yes.
Fertilizer Corporation Institute. Similarly, all three
Yes,
are
we have seen up till 23.
yes, all three were
Yes.
similarly called for, and we appeared in the interview, we passed out. Then, my lord, will come to page 25,
Appointed.
Annexure 5. Part 2 official order manner dated 4/3/1994. We are continuing since 4/3/1995 and last March, my lord, on 4th of
Appointed.
March, we complete 30 years of service. Continuous.
But why 40 days only?
That's what we are saying, my lord. Because under the Employment Exchange Act, my lord, you cannot they cannot sponsor any candidate for the post whose duration is less than 3 months. And we are sponsored through Employment Exchange.
No, even otherwise, a teacher's job, can it be for 40 days?
Yes. It is a classical case of, my lord, human exploration, which is valid to Article 40.
Classical or classic case?
Classical case of human exploration.
Not classical, classic.
Classical case.
Classical.
Yes, that is the case. Perfect English, my lord. Sri Pranjal Datta, son of Sri Rohini Datta, has been appointed as a teacher, demonstrator.
Now,
Then, my lord, second is
okay, all
similarly, exactly.
Okay.
Now, my lord, this continued. Then we even approached the
But
regional.
you, after this appointment for 40 days, you
Yes.
were continued
I am continuing. We are
by
continuing.
orders, subsequent orders.
Yes, continuing. Right, 29.
Extension orders passed from
Yes.
time to time.
That
Press
29.
appointment fit.
Hmm?
Press appointment orders fit.
Terminal
Every
year,
time.
Every separate independent orders.
40 days.
40 days. Now 6 months. my lord.
Now presently it's not 6.
Then, my lord, we approached the authorities. There was no response. Then ultimately we approached the regional labor commissioner, RLC.
Where?
And, my lord,
Page.
page, my lord, 28 and 6. The RLC in the conciliation, my lord, was of the view that the vacancy whenever arises against this superannuation, transfer, resignation, VRS, apartment teacher may be filled up from the ad hoc teachers in phase manner. So, my lord, this was irrelevant in the sense, my lord, we are already appointed in sanction post by the Hindustan Fertilizer Corporation. This negotiation or conciliation has lost its meaning because after serving 30 years, now we are on the verge of retirement without getting any benefit. Then, my lord, will come to office memorandum, which they are relying, my lord, heavily in the ABTV also, encounter also. Page 33, that is of 23rd July 2001, which is not applicable in our case, my lord. It is
Page.
not- Page, my lord, 33 in case 7.
3.
33. First paragraph. The undersigned is directed to say that as per the Department of Personal and Administrative Reforms, dated October 29, 1975, and the Department Personnel and Training dated 30 March 1988, person appointed on ad hoc basis to a grade R to be replaced by persons approved for regular appointment by diary recruitment. Promotion or transfer, absorption as the case may be, at the earliest opportunity. These instructions also provide that whenever an appointment is made on ad hoc basis, the fact that the appointment is ad hoc and that such an appointment will not bestow on the person a claim for regular appointment should be clearly spelled out in the order of appointment. It should also be made clear that service rendered by ad hoc basis in the grade concerned would not count for the purpose of seniority in that grade and not eligibility for promotion to the next grade. Here, my lord, the main theme on them is that there is a embargo by this letter of dated 23rd of July in 2001 that ad hoc appointees should not be regularized. But before that line, my lord, there is clear. It is clear that should be replaced, approved for regular appointment by direct recruitment. We are directly recruited through employment exchange, promotion, transfer, absorption is the case may be. At the earliest stage of opportunity. Over upon 1994 and one is in 1996. This instance also provide that whenever appointment is made on ad hoc basis, the fact that the appointment is ad hoc and that such an appointment will not be sustained. That is not applicable. Moreover, it is prospective, not just prospective so far. Interest of Fertilizer Corporation or, my lord, Coromandel Valley Fertilizer Corporation is concerned. Then, my lord, will come to page 36, Annex 8. It was after the Umadevi case, my lord, on 11th of December 2006. The direct
Page.
page 36, my lord, Annex 8,
Annexure page
36.
36. Yes.
The unsigned The unsigned is directed to state that instruction for engagement of casual workers enunciated in this department OM number dated 7 June 1988 as amplified from time to time inter alia, provided that casual workers and persons on daily wage should not be recruited for work of regular nature. This is clear, man. They could be engaged only for a work of casual or seasonal or intermittent nature, or for work which is not of full-time nature, for which regular post cannot be created. Attention is also invited to this department, OM number dated 23rd July 2021, wherein it was provided that no appointment shall be made on ad hoc basis by direct recruitment from open market. So we are directly recruited from open market. So ad hoc appointment cannot be allowed. That's what this letter says.
Yes.
If it is on pick and choose basis, ad hoc may be allowed. But when you are appointing on the basis direct recruitment from open market, then no ad hoc appointment should be allowed. Then second para, a constitutional bench of the Supreme Court. A constitutional bench of the Supreme Court in civil appeal number so this Umadevi case, madam. In the case of Secretary of State of Karnataka and others, Umadevi and others, has reiterated that any public appointment has to be in terms of the constitutional scheme. However, the Supreme Court in paragraph 44 of the aforesaid judgment dated 10/4/2006 has directed that the Union of India, the state government and their instrumentality to take steps to regularize as a one-time measure in service of such irregularly appointed. We are not even irregularly appointed. Supreme Court says even irregular appointments should be regularized. Irregularly appointed who are duly qualified person in terms of statutory requirement rules for the post and who have worked for 10 years or more in duly sanctioned post. We are in duly sanctioned post, worked for 30 years now. But not under the cover of orders of the court or tribunal. The apex court has clarified that if such appointment itself is in infraction of the rules or if it is in violation of the provision of the constitution, illegality cannot be regularized. Illegality cannot be regularized. So we are not even illegally appointed. We are regularly appointed through selection, through employment actions. There is a compulsory notification for given. And my lord, we had come to court, my lord, wrongly a petition was filed earlier, making Assam government a party and the secondary education department a party. But that was withdrawn and with liberty to and this petition is before the Lord. Now, my lord, in paragraph 18 of their counter evidence, my lord.
Just a minute.
For in seriatim, my lord, this after page marking, page 49, my lord, internal page 10. Counter of the yes, also got my lord.
Which
49.
Page?
49, in seriatim, my lord, that after the pagination
Yes,
and internal page is 10
yes.
of the counter.
Countered by the BPC.
Yes. In paragraph 18, they reply to annexure 1 and paragraph 4 of our petition, my lord, and that is very relevant. They do not deny it as such. What they say is that the statement made in paragraph 4 of the writ petition, the deponent states that annexure 1 of the writ petition is related to the erstwhile Hindustan Fertilizer Corporation and which is not applicable for PVCL. But they are working under PVCL, under their appointment till date. So they do not deny the contents that the posts are sanctioned, my lord, and once the posts are sanctioned, my lord, Uma Devi covers. And since the appointment is regular, as per the constitutional norm, so we are entitled to be regularized, my lord. And we have got very less years to go in service now. Perhaps one. Was 52 in 2019, my lord, when the petition was filed. And now he is about 5 years, 57 years. 57 years.
Petitioner 2.
Petitioner 2, my lord. He may be of same age, my lord, except petitioner number 3, who is bit younger, my lord. He may be now 55 years. Because his appointment is of 1993, 96. So, my lord, we are entitled to regulation and other benefits, it may be potential and desired as well as desired. Because there is really a very serious case of exploitation now. They are getting 12 to 14,000 and after deduction they are getting 89.
Now, even now, after 40 days, fresh order is given.
Presently 6 months
6
appointment orders. But
they say, Malum, whenever we approach, we've been approaching almost every week, every month. They say due to punching machine, they are not in position to issue the order. What is that? I do
Mr.
not know.
Sharma,
yes, Lord.
What
The
is
fact that a bit of a checkered history is there. What has happened is these appointments otherwise were made under the erstwhile company, that is Hindustan Corporation, Fertilizer Corporation. Now that corporation was declared as a Sikh industry and was taken over by the board, BIFR board, for closing it down. If a lordship will come, first of all, let me just take your lordship to that annexer 1 of the writ petition, wherein an indication is sought to be given that these particular posts which were filled up were against sanctioned vacancies, and therefore the list was shown. That is at page 18.
yes,
Page 78. Now, this otherwise, the lordship will come to page 7. This is otherwise the inter-office communication of 27/9/1991. Now, though it talks about the number of sanctioned posts there, but this is particularly, if you lordship see number 4 of that particular office memo.
yes,
Now you may initiate promotion action in respect of unionized category as well as officers below corporate level posts as mentioned above. However, before filling up the post of officers of promotion, prior approval of the corporate office may be obtained. So this list of 1991 was basically to deal with certain promotional activities that the erstwhile corporation was trying to take at that point of time. Now, to associate or link this document with this particular ad hoc appointment of 1993, there is no basis or there is no evidence to show that this ad hoc appointments which were made in 1993 was against the sanctioned post. Why I'm saying so? Because the categorical stand of BVFCL today in the affidavit that these ad hoc appointments were never made against sanctioned posts. The very fact, because the call letter would indicate that these were for ad hoc posts. That will also be find page 19. The petitioner is trying to link this document, wherein that total amount of sanctioned posts is provided in the inter-office memo, to the present appointments of 1993 to indicate or to show that these were made, the present appointments were made against those sanctioned vacancies. But then that to bridge that link, there is no document to show. The document that the petitioner has annexed page 19 is the letter, first we'll come to page 19, next page.
yes,
That is one of the petitioners, Pranjal Datta. The subject, framing panel of ad hoc teacher come demonstrator, physics, chemistry. The Employment Exchange Namrup has sponsored your name for the above mentioned post. You are requested to appear for interview before the select committee on such a date in the administrative office of Hindustan Fertilizer Corporation, Assam. You should also bring your diploma certificate such as no traveling allowance to be. The very subject indicates that this was for framing a panel of ad hoc teachers. There is no indication anywhere that these were regular posts to be filled up. And it will be a different case altogether had there been advertisement for filling up regular posts. The petitioners had participated, but when the appointment letters were given to them, they were appointed as ad hoc. That will be a different case altogether. But here is the case where the initiation of the process of appointment was on the contemplation that these will be ad hoc appointments. And they were called to appear in an interview meant for filling up the post on ad hoc basis, without any reference to the fact that these were otherwise regular vacancies or they were against sanctioned posts. So the letters of calling them for interview, the initiation letters would indicate that these were not for regular sanctioned posts. And the stand taken by BPSL today is that these appointments were never sanctioned. The inter-office memo at page 91, what I am saying is this is not related to the present appointment. This is something to deal with promotion issues of the unionized categories of their employees. So this associating the 91 document with the present appointments of 1993, there is nothing in between to bridge them. The petitioner have just annexed the document to create an impression that this was against the sanction. These appointments were against sanction. That will be my first submission on the aspect of that these has to be taken that these appointments were against sanction. Number one.
Now, number two would be pursuant to these calling them for ad hoc appointment. They were given their appointment on ad hoc basis. The appointment letter itself indicates, if a lordship will come to the appointment letter at page 26. The initial appointment letter
Yes.
under the Hindustan Fertilizer Corporation. Subject: recruitment to the post of teacher, science, maths on consolidated pay of rupees 1,000 on ad hoc basis for a period of 40 days. So it also says ad hoc basis. Then with reference to your particulars sponsored by the Employment Exchange and subsequent interview for the post of teacher, you are hereby offered the post of teacher on the following terms and conditions. You will be paid a monthly consolidated amount of 1,000. Your services will be purely on ad hoc basis for a period of 40 days only. And then if your lordship will come, the other conditions that are not relevant. If your lordship will come to the last paragraph, in case of the above terms and conditions are acceptable to you, you are requested to report for duty in between 1394 to 7394 to your principal SS school through personnel department, failing which your offer for appointment can automatically cancel without the person. So it was also subject to an acceptance by. So the petitioner always knew that he was giving his candidature for a selection process that was meant to fill up ad hoc posts, number one. Number two, pursuant to his selection, in the appointment letter itself, it was categorically stated that your appointment is against an ad hoc basis. It is on an ad hoc basis, and he was even given that option of accepting it. So, with eyes wide open, the petitioner had entered into the service, accepting his conditions of employment. And one of the vital conditions of employment was that it was an ad hoc basis. So, to link it with a sanctioned post and thereby to give an impression that he had gone through a regular selection process, but he was deprived of a regular posting or a regular appointment, and he was kept on an ad hoc basis. Otherwise, there is no material on record to indicate that to come to the side of the petitioner's favor. Because the petitioner is trying to make out the case that there was a sanctioned post, but they are working on ad hoc basis. So therefore, Uma Devi comes in. LM Kesari's husband also comes in, which says if there's sanctioned post, the government has the power of a one-time measure to regularize it. That is basically the case of the petitioner. So I'm trying to differentiate by saying that it was never that case. Now, this is the position of HFCL. While the erstwhile HFCL was there, these appointments have taken. Now, we are a new company. Brahmaputra Valley Fertilizer Corporation is a new company. In 2002, very pursuant to the failure of the erstwhile company to run profitably, it was declared as a sick industry. And then the board, for the BIFR board, decided to close this. Then the central government gave a proposal that there is a Namrup unit. Namrup fertilizer unit is there, factory is there. Let that factory alone run in the form of a new company. And accordingly, a new company was incorporated in the name of BVFCL in 2002. I have stated in paragraph 2002. And that particular company is now running the Namrup industry, however, at a loss. Now, there is one judgment. I am not carrying the judgment today. We are still declared as a sick industry. In a sick industry, there is
Who's declared? BPCL or HFCL?
HCFL. HFCL is already gone. That company is closed.
Now, by a BIFR resolution, a new company incorporated had taken over functioning of one of the units.
Yes, only one of the units.
Are you a sick industry?
Yes.
Where is the declaration?
So, lordship will come to the affidavit that has been filed by us. Annexer
page
55. Running page 55. Annexer R1. I do not have the certificate from BIFR annexed in this petition, but this is one document of the company. It otherwise gives the indication.
Where is it? 55.
Page. Got that? Annexer R1.
Yes.
Yes. BVFCL is a loss-making company since its incorporation since April 2000. The company is an incipient SIG company as per the guidelines of the Department of Public Enterprise, Ministry of Heavy Industry Public Enterprise, copy that is just enclosed. The clause number 4.2.a of the guidelines will be referred. As per the above guideline, BBFCL is a incipient SIG CPSC, as its net worth is 50% of the paid up tax. So this document otherwise gives an indication
What is an incipient SIG company?
that I also will have. I think from inception 6. I think it should
Is
be-
there any declaration by the BIFR regarding your company?
I think the document is there on record and not have it, but my instructions are that SIG industry, that declaration or the status is still there. I can get the document. Now, a Supreme Court ruling is they are not even carrying that today, says that the SIG industry regularization may not be possible. And this is, I'll produce this. Because it's already SIG. So the luxury of having regular employees in a SIG industry probably is. And one more aspect, I must clarify that the petitioners are
How many teachers are there?
these are three teachers.
No, total. There are 4, I think.
Three.
Three people. Okay. How many teachers are there?
17 as per the list, my lord.
17.
117.
117.
that
That
is
was the sanction
I do
strength.
one thing.
Now, how many of teachers are discharging?
Present position,
School is up to what level? Matriculation?
higher sec-
Hi- From class which? It's a higher secondary school
Higher-
only. 11 and 12.
Yep.
Okay.
From 5 to 12. 5 to 12.
5 to 12. So how many students are there?
I do not have to. Yeah, so
Around 600.
This may not be fair, Mr. Sharma.
no, I understand. I otherwise sympathize with their case. But then what I'm trying to say to logic is that
This is a direct exploitation. On this count, technical ground, that technical ground, you are exploiting them.
My lord, the
You say that the choice was given to them. It was an offer. They accepted. Do they have any choice? In 1994, when a person, graduate, is given an appointment, that these are the conditions, we want your acceptance. Will he have the same bargaining power?
but then also this matter
And from 1994 to 2024, 30 years as a teacher.
from the point of equity, I understand, Lord. I understand. But then there are limitations for the company also, which I need to project with your lordship in a SIG industry. That I will have to probably project with the
No, that,
only their brief.
no, you have done your part. Who are the respondents?
One more aspect I would like to point out.
Union is there. Union of India is there.
Yes, Lord.
Yes. What is the other aspect?
Yes, Lord. Another thing is that this matter had otherwise went for an adjudication before the conciliation officer under the industrial.
Oh, that we have seen, yes.
Yes. So there was certain meeting points between the company and the teachers, wherein one of the conditions was that they will be given equal pay to the other regular teachers, which they are otherwise enjoying.
Mm.
Wherein they have, however, signed that.
Mm. Yes.
Lord, the PBSCL took over the Hindustan.
We'll come to you. We'll come to you. Let him finish.
Just give me a moment.
Page 28. 28.
Just give me a moment. We'll also come to the affidavit filed by us. Annexer R5, I don't have the one. Running page number is not that, I apologize. For page 34, internally is 34
Of your affidavit.
of our affidavit. Annexer R5, internal page 34.
It's a package, minutes of proceedings.
Minus the proceeding. Yes,
Okay, yes.
yes, sir.
74.
Page 70.
Yes,
May I just read this first. So
please.
all were representatives were there from the company as well as the present petitioner.
Hmm.
Now, if your lordship will just come to the starting of the narration.
Hmm.
Both the representatives of the union and the representatives of the ad hoc and contractual teachers raised the dispute.
Yes.
Both the representatives of the union and the representatives of the
yes.
ad hoc and
Hmm.
contractual teachers
Hmm.
raised the dispute to regularize all ad hoc and contractual workers along with the following demands.
Hmm. Hmm.
Enhancement of the existing salary by way of calculating basic and TA, to provide LPG facilities to all contractual teachers and employees, medical facilities, both inpatient and outpatient treatment, along with reimbursement of medical fees. The management of BVFCL stated that a bipartite meeting held on 23/3/2015, wherein the management's view over all the above note demands communicated to both the union for regularization of ad hoc contractual teacher will not be possible. As per the terms and conditions of the present appointment of ad hoc contractual teachers, they are continuing the service on 6 months contract basis with a consolidated pay fixed by the management. The ad hoc teachers are provided LPG facilities, but however, to extend the same facilities to the contractual teachers, it will be taken into consideration by the management. At present, all the ad hoc and contractual teachers are provided medical facilities such as free consultation in the case of outdoor patients and concessional rates in respect of bed charge, investigation towards X-ray and all laboratory stages in patient, reimbursement of medical treatment in respect of ad hoc contractual teachers and staff as demanded by the union and the group teachers is also not possible. Representatives of the union stated that at present 10 ad hoc teachers, 15 contractual teachers, and a few ad hoc contractual employees are working in medical departments of BPFCL. The union further strongly demands not to deprive the state ill-fated employees from their rights and privileges. Considering the above and circumstances narrated above, the RLC, that is the Regional Labour Commissioner, Central, Conciliation Officer advised the management to resolve the issue as per the following suggestions. Number one, enhancement of salary of ad hoc contractual employees may be considered based on the basic and DA at par with the perennial nature of job for permanent employee. Reimbursement of medical facilities may be considered by way of restriction with a certain amount per year. Providing LPG facilities to the contractual employees may be considered in consultation with the authorities of IOCL. In case of regularization, ad hoc and consultation may be further reviewed as per meeting of the last consultation. The consultation officer further requested the management to furnish. And this has been otherwise thereafter signed by all the representatives, including the ad hoc teachers representative. So now there was a conciliation proceeding that had taken place. They had submitted themselves to the industrial dispute mechanism for resolving disputes, wherein these particular advices were given, and based on that, they are now enjoying salary at par with the other teachers who are doing perennial nature of work, of the same nature of work. So otherwise, they are
How
not
many
deprived.
permanent teachers do you have?
That these instructions I not have because
No permanent.
that is another fact. Lord.
No,
permanent
that
teachers
is what is of concern. You are running a school for the 30 years on ad hoc basis.
BVFCL is not running the school for 30
No,
otherwise.
a school is in existence. That is not in dispute.
Because this is a new company otherwise.
No, what is the MOU? By
Again,
which
I am
or
not-
BIFR resolution? by
Today I
which-
am a bit handicapped
See,
because these documents are not the matters.
See, as is
came
where
up.
is normally is
The
as
lawyer
is
will give me
as is
around
where
10
is
days time.
basis. No, we are not
No,
adjourning.
because if I can just furnish this document for
No,
not
we are
to
not
indicate
adjourning matters.
only one more thing. If a lawsuit sees that the present appointment with BVFCL today is for 6 months. So the earlier appointments have spent its course. These were for these, those appointments were under the erstwhile company. So what presently is existing is this 6 months appointment.
You cannot wipe out the earlier services rendered by a mere statement that we came into the picture later. So they are our appointment for a particular date. We will not recognize.
And
School is
And
continuing.
also another aspect will be whether these were against sanctioned posts, whether there are sanctioned posts actually existing. That position also I need to clarify. Because again, for Uma Devi to come in, that precondition has to be satisfied if it was sanctioned post. Because my categorical instruction today in the morning was these were never meant for sanctioned posts. These document of 91 that they are relying upon.
So
have
how
got
do you
no-
run a school? Tell us. Will you run a school on ad hoc basis from years together? Is it a job
is-
of
this is
seasonal
basic-
nature?
This is basically of a social service nature.
No, no,
because the
it's not.
students have to be
See,
continued with
nowadays,
education.
after CISR, you need to do a lot of other things. This is a school for your own employees. The sons and daughters of your own employees, mainly.
Had it been some other company, that things would have been different. But this is a Sikh industry. Now again, that
Sikh
status,
industry,
how
the
far-
Sikh industry may not, we are not asking you to indulge in some superfluous activities. This is minimum salaries and
the
regularization of the,
salaries that they are getting otherwise.
and the regularization. Now they are retiring without getting any retirement benefit, post-retirement benefit. Is it fair?
Regularization will
And
also
that a
not.
teacher's job, the
I-
amount of respect a teacher earns.
that I
Only in
understand.
a country like India, we don't respect teachers. Go to Japan, most respected, much above any other job.
Will also give this time so that I can have
No,
specific instruction.
we are passing orders.
Just on the instruction regarding that status of a BIFR Sikh industry vis-a-vis
No,
regularization.
even if you are a Sikh industry, that much you can, I think that is not to be a
Officers are getting salary,
luxury we are imposing upon you. This is something very basic.
One thing I may just point out, in 2020 to 23, the PBCL, the turnover was 1,050 crore. And they are making profit. It is no more sticking. The government is India.
Now that is like his word against
No,
my
no,
word.
that-
I can
tho-
produce the
tho-
document
tho-
to indicate the profit and
No,
loss.
Due
no,
account.
that
respect,
is
due
immaterial.
respect,
That
Mr.
is
Sharma,
that is
we'll
immaterial.
record both of your statements, but we are not going by that.
Yes.
It is a fact that BIFR, this Brahmaputra Valley is running the unit. It may be a loss-making unit, but the school is also is
That-
in operation for the last
They-
30
They
years.
took over, my lord,
School
in-
has not been shut down.
they took over in 2002.
My paragraph 20 maybe kindly just reduce one that it's
20 of
20 of the affidavit, wherein we have indicated that this was a Sikh industry. The earlier RCL company was closed, BIFR took over, and now BBFL is a new company.
Hmm.
And this being a Sikh industry, we do not have the luxury of giving regularization. That paragraph 20
So
in
the
entire-
officers you are appointing.
because that is the basic crux of our defense. Paragraph 20.
No, you could have shut down the school.
That will again be
Why?
like the students will suffer. That
No, why? Why you are interested in the students? You are not interested in the teachers who impart the education.
salary they are getting. That's what I'm trying to
Salaries.
impress the salary they are
Can
getting.
you make it so uncertain of a person who dedicates his life 30 years, then suddenly he is nowhere? Will it be fair? Just imagine. 30 years he dedicates on a salary. Of course, he's paid a salary, but can you just say, no, we have paid your salaries?
personal level?
This
I
is
agree.
not a contract for a
Personal level,
particular
I agree
work.
to it, Raj.
This is with a BPCL.
My only request to your lordship would be to take note of paragraph 20 of the affidavit and pass
Yes,
orders thereafter.
I'm taking over. Okay.
And my submission that these posts were not sanctioned posts, and therefore, but it will not come.
Okay, then those you have. Three petitioners have joined together in this petition filed under Article 226 of the Constitution of India with the primary contention and claim relating to regularization of their service. Full stop. Para. The facts projected in the petition is narrated briefly as hereunder. Full stop. The petitioners are having the qualification to be appointed as graduate teachers. Full stop. the erstwhile Hindustan Fertilizer Corporation Limited was having a school in its campus, and pursuant to a recruitment drive, the names of the petitioners which were enrolled with the concerned employment exchange were forwarded. Full stop. Pursuant to such forwarding, in the year 1994, the petitioners were appointed, however, for a limited period of 40 days. Full stop. It is the case of the petitioners that such appointments were extended from time to time, and as on date, the petitioners have completed more than 30 years of service. Full stop. Subsequently, the duration of the appointment was enhanced from 40 days to 6 months. Full stop. The issue regarding regularization of their service was taken up by the petitioners through the Regional Labor Commissioner in the year 2014, and there was a proposal to the management to fill up the existing permanent post from the enlisted ad hoc teachers if they fulfill the required education qualification. Full stop. It is contended that no action was taken pursuant to such recommendation. Full stop. In the meantime, the Hindustan Fertilizer Corporation Limited was declared sick, and under the aegis of the BIFR, a new company was incorporated, namely Brahmaputra Valley Fertilizer Corporation Limited, which took over the unit
With effect from 5/4/2000.
Unit at Namrup with effect from 5/4/2002. Full stop. The matter was again taken up before the Regional Labor Commissioner, even after which no steps have been taken for their regularization. Full stop. The petitioners had earlier approached this court by filing WPC 6/2007, which, however, was withdrawn on 6/9/2018 with liberty to file afresh, and accordingly, the present petition has been filed. Full stop. Para. I have heard Sri R.P. Sharma, Learned Senior Counsel, assisted by Sri S. Dihingia for the petitioners. Full stop. I have also heard Sri A. Sharma, Learned Counsel, for the respond numbers
228.
228. Full stop. Any CGC? Anyone CGC? Who's there? Mr. Roy is there? SS Roy? Mr. Dhar, SS Roy is there? Is in the court otherwise? Okay, Sri S.S. Roy, Learned CGC is also present. Full stop, para. Sri Sharma, the Learned Senior Counsel. Sri R.P. Sharma, the Learned Senior Counsel. By referring to an inter-office memo of the erstwhile HFCL dated 27/9/1991 has submitted that the said memo, the said communication was with regard to classification was with regard to the revised sanction post and in the summary attached thereto, comma, the revised sanction strength for teachers was given as 117. Full stop. He submits that the communications issued by the HFCL to the petitioners on 12/11/1993 would establish that their names were sponsored by the Employment Exchange Namrup for appearing in an interview before the selection committee on 2/12/1993 in the office premises of the corporation. Full stop. The petitioners were also directed to bring with them the relevant degrees, comma, diploma, certificates, and other testimonials, including proof of age, qualification, comma, experience, etc. Full stop. It is submitted that pursuant to such selection process, comma, the petitioners were appointed in the year 1994, which, however, was for a period of 40 days. Full stop. The petitioners were, however, given a certain employee number. Full stop. As the appointments were limited by time and was extended and had to be extended from time to time, comma, the matter was raised before the Regional Labor Commissioner, Dibrugarh, pursuant to which a resolution was adopted on 5/9/2014, wherein certain recommendations were made, including the requirement to fill up existing permanent posts lying vacant from the ad hoc teachers, which, however, was not done. Full stop. Para. Sri Sharma, the Learned Senior Counsel, has submitted that the continuation of the petitioners for a period of 30 years, who otherwise meet all the requisite qualification and had entered into the service as teachers through a selection process cannot be denied the benefits of regularization, as that would amount to exploitation of labor. Full stop. It is also contended that the initial appointment, though termed to be ad hoc, would not come into the way for considering the aspect of regularization of their service, inasmuch as the nature of job is such that it is inasmuch as the nature of job is perennial and there is no dispute regarding their qualification to hold such a post. Full stop. It is submitted that the status of the petitioners has been kept uncertain and immediately on their retirement, they would have no means or resource for their survival. Full stop. The senior counsel accordingly submits that appropriate directions be issued for regularization of their service so as to ensure that they are not deprived of the post-retirement benefits. Full stop. Para. The learned senior counsel further submits that the mandate of the Honorable Supreme Court laid down in the case of State of Karnataka versus Uma Devi 1, reported in so page 1, would not be an impediment for their regularization, and rather their cases would fall within the scope for such regularization as laid down in paragraph 53 of the said judgment. Full stop. Para. Per contra, Sri A. Sharma, learned counsel representing the BVFCL, has submitted that the present corporation had come into the picture only in the year 2004, after the erstwhile company was declared sick by the BIFR. Full stop. He accordingly submits that the induction of the petitioners in service was initially against a different company, and therefore the present respondents cannot be saddled with the burden of regularization of the services, more so when the company is still a loss-making company. Full stop. He, by referring to the document annexed as the document dated 4/3/2017, Sri Sharma has submitted that his client corporation is an insapient sick company. That is the expression?
Yes.
Insapient sick company. And any direction for regularization may not be feasible or feasible. Full stop. By referring to the orders of appointment as projected by the petitioners, he submits that the aforesaid orders were only offers under offers wherein certain conditions were attached, and the petitioners on their own volition had accepted such appointment along with such conditions, and therefore they would be precluded from making the present claim, full stop. He submits that the initial appointment was not done. He submits that it is not the case of the petitioner that the initial appointment was done through an open advertisement and open advertisement, and therefore the embargo in the case of Uma Devi would still be applicable, full stop. The learned counsel, by referring to the communication dated 27/9/1991, has submitted that the interpretation sought to be given by the petitioner may not be a correct interpretation, as the same was only to facilitate initiation of promotion action in respect of unionized categories. And the summary attached thereto cannot be linked with the purpose of the said inter-office memo. We'll come back at 2 o'clock.
I'll just place two judgments on that.
Ini mari di balas line to KSL fellow.
B.
Yes,
Case
we
11.
will consider those.
Yes, just for my,
We have read that.
just for my satisfaction.
It's not a question of satisfaction, it's a question of time. We have read that 20. We'll
Yes,
take care of.
I have taken the ground that these are not sanctioned posts.
We have,
And against that, I'll just place two judgments that is-
we have Kesari and Upendas.
and open that.
Okay.
Kesari, paragraph 7, which says the
We'll
precondition.
take care of your argument,
Yes,
don't worry.
and open that paragraph 8.
Yes.
I'm also placing, my lord, paragraph 18 of their affidavit, my lord, where they have denied their connector 1. Yes.
Promotion. Action. Promotion. Action. In respect of unionized categories. By dealing with the conciliation proceedings before the Regional Labor Commissioner, Dibrugarh, the Learned Counsel for the Corporation has submitted that apart from the proceeding of the year 2014, which has been referred to by the petitioners, comma, there was another round which had culminated in a minutes dated 27/3/2015, full stop, by referring to the resolutions therein, comma, the learned counsel for the respondent corporation has submitted that there was no resolution for any regularization of service, and the resolution was only for enhancement of salaries for ad hoc oblique contractual employees, which has accordingly been done. Full stop. He clarifies that there is no dispute or any issue with regard to the salaries presently paid to the petitioners, which is at par with the permanent employees. Full stop. It said,
They say, Maharaj, they are getting only 12.
no, there his submission.
Okay.
Oh. Para. The learned counsel for the corporation, by referring to the averments made in paragraph 20
just a-
of the affidavit in opposition filed on 2/6/2020 has submitted that the defense of the corporation has been adequately stated in the said paragraph, full stop. It is submitted that the fact as to how the present corporation was incorporated and had taken over the earlier, the unit at Namrup of the earlier, of the erstwhile HFCL, comma, the temporary nature, temporary engagement of the petitioners, which was in the form of an offer, comma, the ad hoc appointment and lack of any sanction post have been clearly stated in the said paragraph. Full stop. Para. The learned counsel for the respondent corporation has also relied upon the cases, relied upon the case of State of Karnataka and others versus M.L. Kesari and others reported in 2010 9 SCC 247, and also the case of this court in state of Assam versus Upendas reported in 2017 4 GLR 493, full stop. He submits that regularization cannot be claimed as a matter of right and only on fulfilling the conditions precedent, namely holding of adequate qualification, comma, entering into the services by a recognized process of law, and existence of sanctioned post in which such accommodation was made are the preconditions which would have to be fulfilled by an incumbent. Full stop. He submits that the aforesaid preconditions are not met
but
by the,
only the,
even you say sanction post and there was no advertisement, you have said.
I am saying
Oh.
that is there, and I'm saying
Are
because
not
they were
met.
against the sanction.
are not met by the incumbents. Full stop, para. 3, the learned counsel accordingly submits that no relief can be granted to the petitioner. And accordingly, the writ petition should be dismissed. Full stop, para. 3. R.P. Sharma, the learned senior counsel, in his rejoinder, has referred to the averments made in paragraph 18, is it 18?
Yes, 18 in the countermand.
18 of the affidavit in opposition, which is a reply to the averments of the petitioners made in paragraph 4. Full stop. It is submitted that specific statements were made in paragraph 4 of the writ petition to the extent that the total sanction strength of the teachers was 117, and there was no denial to the aforesaid aspect. Full stop, para. The rival submissions have been duly considered, and the materials placed before this court have been examined. Full stop, para. The induction of the petitioners in their services was in services in the year 1994 was pursuant to a selection process which would be revealed from the communications dated 12/11/1993 issued by the erstwhile HFCL. Full stop. A bare look at the said communication would reveal that an interview was scheduled on 2/12/1993 for the selection, in which the petitioner was directed to appear as his name. Petitioners were directed to appear as their names were sponsored by the concerned employment exchange, Namrup. Full stop. The mode of forwarding names by the concerned employment exchange is a recognized mode in law for holding a selection process. Full stop. The said communication would also reveal that in the said selection, the testimonials of the petitioners pertaining to their educational qualifications and other factors were also examined. Full stop. There is also no materials on record to suggest that the petitioners are not qualified to hold the post of teachers which they were appointed by the orders dated 24/1/1990. 24. Appointment orders of 1994. Full stop. it is a para. Though it is a matter of fact that the appointment, initial appointment was for a limited period of 40 days, which was extended from time to time, comma, this court is unable to accept the submissions made on behalf of the corporation that the aforesaid stipulation, that the aforesaid appointment with the stipulation of 40 days was only an offer which was accepted by the petitioners, full stop. Such acceptance by the petitioners cannot be construed to mean that they are precluded from raising any issue, any claim towards the regularization of their service. Full stop. In the present scenario regarding the scarcity of employment, comma, the bargaining power of an incumbent who has been offered a particular post cannot be held to be at par with the employer, and therefore the question of any estoppel coming in the way of such claim would not arise. Full stop. Para. The issue would therefore boil down to the aspect of the fulfillment of the conditions by the petitioners in their claim to justify their claim for regularization. Full stop. There is no dispute that the petitioners are rendering their services as teachers in the school for the last about 30 years. Full stop. The qualification of the petitioners to work in the said capacity is also not disputed. Full stop. The only dispute which has been sought to be raised is with regard to the sanction post. Full stop. To examine the said issue, comma, this court has looked into the inter-office memo which contains, which would reflect that the revised sanction strength of teachers in the school is 117. Full stop. Though the said memo may be with respect to a process of promotion of unionized categories, comma, the aforesaid fact regarding the revised sanction strengths cannot be ignored or overlooked. Full stop. The entry of the petitioners in the service was through a method wherein their names were sponsored by the concerned employment exchange NAMRUP, and admittedly, comma, the communications issued to them by the HFCL had mentioned regarding a selection process which was scheduled on 2/12/1993, and only after being successful in such selection, comma, the petitioners were inducted in the service. Full stop. Para. The contention that the recommendation of the RCL was not in respect of the present claim would not be of much relevance as the issue of regularization has been independently raised in the present petition, full stop para. The fact that the petitioners are rendering their services as teacher for a continuous period of 30 years would would lead this court to come to a conclusion that they cannot be left in a position of uncertainty on their retirement from service on attaining the age of superannuation, full stop. The entry of the petitioners into the services being through a selection and there being materials on record that the post in which the petitioners are working are sanctioned post, comma, their claim for regularization of the service cannot be denied. Full stop. This court is also of the view that leaving the petitioners high and dry without an order of regularization would amount to exploitation of labor, which is not permissible under the law, full stop para. In view of the aforesaid discussion, comma, the writ petition is allowed by directing that the services of the petitioners be regularized. Similar service of the petitioner as teachers in the Brahmaputra Valley Fertilizer Corporation Higher Secondary School be regularized, and accordingly all consequential benefits be given to them, full stop. Writ petition accordingly stands allowed.
Let me
The aforesaid exercise be undertaken and completed expeditiously and in any case within a period of 4 months from today.
Obliged.
Bora, well, so left the court.
Who?
Ms. Bora,
Okay.
Health Department.
You are also health, madam.
Requested,
D is replaced by A.
has requested to take 2 weeks time for filing affidavit.
Affidavit, 2020 matter, affidavit, why? Till now you have not filed affidavit, you are not interested to file affidavit. Yes, what is the matter?
Other senior counsel Month was waiting, but
Mhm.
first half of
Who?
Month.
Okay, he'll be appearing.
Yes, but and now he is standing in another court.
What is the matter about?
Otherwise, an MU, Memorandum of Understanding was signed between the Union and the State of Assam,
Union of?
India,
Okay.
and between the State of Assam
Regarding?
regarding a pilot project for prevention of the burn injuries.
Okay.
Yes. There, in this MU, district in Dhubri district, the Dhubri Civil Hospital and Nagaon district, Nagaon DMC was identified for functioning the facilities to prevention of burn injury.
Okay.
Accordingly, Lordship, an advertisement was issued 2014, and the present petitioner
Advertisement for?
dresser, Safai Gormi, and
Okay.
some stuff. And 2014 was, and petitioners were duly appeared, Lordship, and they were selected and they are. And since
In Dhubri and Hoja, Dhubri and which district?
Nagaon,
Nagaon, okay.
since 2014 to 21, they are paid salary. And thereafter, Lordship, in 2020, a notice was issued from the government that their service be discontinued till 2001, March 3, they will be discontinued. And this notification was challenged before the Honorable Court.
earlier?
That was its state. And till now, Lordship, no salary has been paid to the priest and not their service of regular. Otherwise, there is a communication between the government officials.
That stay order is still pending,
Yes.
still operating.
Yes,
And which writ petition?
yes, Lordship, in 661.
It is also there
Yes,
in the
yes,
group.
yes.
Okay, thereafter you are not getting the salary.
In,
Okay,
otherwise, in Lordship, next writ petition, that is Lordship, in that writ petition, they filed an affidavit and they have taken a step. They are going to regularize their service. It is clear. So their prayer may be allowed to fix a date.
there may not be any dispute, madam, because this pilot project cannot be abandoned. And this is not a temporary problem. This may happen at any time.
Yes.
And having a hospital of specialized nature to look into victims of this kind, victims or maybe whoever, and the stay order is there. And are you aware of the facts? No.
Yes.
Okay. When?
Lordship, a date of
When?
10 days.
yes.
After 10 days?
Yes.
Okay. On a joint request made on behalf of the parties, comma, these, एक ही case, एक ही order, बहुत ही. These matters are adjourned to be listed on
10th
Ma-
of, 10th,
Huh?
10th of May, 10th.
Madam? On 10th May. Not 10th.
Yes.
10th will be a Friday. We'll
Yes.
have it on 9th.
Yes,
9th, we'll dispose this off.
Yes.
9th,
they are allowed to file a petition.
whatever.
I know. How does that?
When response will be necessary, Lordship. Matter relates to,
There.
he is for the private.
I'm sort of not for.
Who is for the petition? The state of Assam?
Matter relates-
What is there?
PATK, I think, Deputy Commission,
Who is there?
Lordship, that I can take it.
Hmm.
Also, matter relates to the promotion from grade 4 to grade 3 under the Assam Ministerial District Establishment. Lordship. The
Which
state part-
77? Which rule? 77 rules?
Lordship.
77 or which rules?
Like 67.
67. Grade 4 to?
Grade 4 to grade 3. Lordship, I prepare the SOP and also the citation on which I am relying.
Yes.
Lordship, the petitioner number 1 was appointed in the year 1993
Which department?
under the Deputy Commission as a process server. Lordship.
Hmm. In the same office?
Same. And petitioner number 2 in the year 98,
DC of which
Uh,
district?
Hailakandi. And petitioner number 2 as peon in
Okay.
98.
Okay, yes.
Now, under the rule, Lordship, after 7 years, we are entitled and both are HS pass, Lordship. Now, if the Lordship comes to the gradation list, Lordship,
The requirement is HS or graduate?
now after 2015, it is graduation. My case is on Rangaya, but Rangaya has been diluted by the subsequent judgment. But my submission will be, Lordship, whether the vested right that can be impaired, Lordship, by a, because they admit till 2019, not a single person has been promoted from grade 4.
No,
So
if
cadre
the-
strength is 41.
No,
4%
Mr.
4% can be
Mr.
accommodated.
Chakraborty, if you succeed
Lord.
and there is a consideration for your, there is a direction for your consideration,
Lord.
then that consideration has to be done today.
Lordship.
It cannot be done with a retrospective effect. It might be given retrospective effect, provided you have the qualification as it required today.
They admit that till 2019 lordship,
That
there was a
factor,
vacancy, there was a vacancy,
that factor will be against you.
there was a vacancy.
That factor will be against you. If your case would have been that persons like you have been promoted in earlier point of time and you are left out, then
But
the
they never initiated any process.
and
for-
who are you?
He has been promoted, he is graduate.
When?
I don't have any grievance in.
You're a
in
graduate.
graduate.
Then sit down. Saved.
He is graduate. Lordship, recently this justice, court number 5 has passed one order.
See, we cannot tinker with the requirement of qualification. That is not permissible in the law. If it's graduation, is graduate is graduate.
Here also the Ranga case was considered, and as well as the state of Himachal Pradesh Rajkumar case was also considered.
Even the higher secondary has been given, directed to be given.
Not.
Huh?
Not.
But won't that be in the par inquiry of the Supreme Court?
Para 18 and lordship para. In 18, it is discussed from a conjoined reading of the minus reading as well as 22, but as well as the department has taken consideration to close the channel from prospect from 9 is the right consider considering is one vacancy supposed to which prior to amendment would tested under the judgment and order dated 22 wherein the specific candidate are considered for promotion. Therefore, by the subsequent action taken effort in meeting required to favor under the judgment which not have been taken with the
The issue is not the same.
not
Issue is
directly, but
issue
there
is
was a
different.
order in earlier round of litigation.
Issue is different. Mr. Dhar, have a look. We thought that the issue is same. It's a different issue.
My lord,
And just have a look.
my-
Amendment came when?
2015.
15.
my affidavit, my lord, there are 13 in covered.
Para 13
Yes, my lord. Page number 6,
by R2,
R2, my lord.
Rohan Kumar Jha.
So, my lord, this is response number 2. Doimari, my lord. That's the additional affidavit. That is additional affidavit by
Okay,
first addition affidavit in opposition. My lord.
okay,
Additional affidavit by Jha and other is by Doimari.
okay. Jyotirmoy Doimari.
Doimari.
Paragraph
13, 1, my lord.
one, 3. Okay.
My lord, that is about, it's about appointment, my lord. Who has made the appointment? From there, this direct. We are not here conflict, he is in the same office.
Please read 13 here.
That with regard to the appointment made in para 13 of the writ petition, herein the petitioner is correct and the answering department said that as the total vacant posts are 22, out of which only 2 posts can be filled up by
Yes.
promotion in the ratio of 90:10. out of 2 posts, 1 post has been filled up for promotion, that is reference number 4. And remaining 1 post is lying vacant due to the lack of candidates having physics qualification, graduation as per notification of 2015. So, my lord, that is the thing. If we have, my lord, even a vacant post even, we cannot fill it up by a person who doesn't have a qualification, my lord. That has to be, my lord, prima facie, my lord, he has to that, my lord, qualified graduation, my lord. And now, my lord, what happens in additional affidavit, we have stated that whatever this vacancy we had, we have already forwarded the vacancy list to the government for direct recruitment. As of today. We may have, my lord, vacant position, my lord. He has to,
Why
my
have
lord,
you sent to the government?
my lord, for direct recruitment, my lord, because we need people, my lord. There are, we cannot.
Or you
promote
don't have eligible persons to be promoted?
promoted.
So you want to fill up the,
We have to fill it up, my lord. We have stated that in our additional affidavit, there are 3. Not even for grade 3, even grade 3 and grade 4, my lord, whatever we had, my lord, vacancy, we have forwarded to government for direct recruitment. Since we need people.
Mr. Chakraborty?
Lordship, I'm on the vested right whether that could have been impaired.
Okay,
On
Hard-
which is crystallized by 2015, before 2015.
okay. Okay, heard.
Total.
Sorry,
Lordship, I just want this court decision on
Okay.
this vested right and lordship.
yes. Now will be divested of your rights.
Lord.
3, 3, 6, 6, 6, 8, 20, 20.
Lordship, 1976, PSCC page.
Your IH Barbia. Yes,
Lordship,
Mr. Counsel.
Vijayalakshmi Rice Mill.
Mr. Counsel, your IH Barbia.
Uh,
Your name IH Barbia. R4. R4.
Paragraph 5, Lordship.
You are referring to Vijay Lakshmi.
Vijayalakshmi Rice Mill. What's the state of it? Paragraph 5, Lordship.
1976,
Lordship.
Free SCC
The three-judge bench.
37. Rice. Yes, which para?
Paragraph 5, Lord.
5.
May I read, Lordship?
Yes, please.
Mr. Nariman, appearing on behalf of the appellant, has laid great emphasis on the word substituted occurring in clause 2 of price control order 1964, and has urged that the claim of the appellant cannot be validly ignored. Elaborating his submission, counsel has contended that the price fixed by the government are meant for the entire season. The appellants have to pay at the control price that fixed by the price control orders from 1964, regardless of the date on which the supplies were made. We cannot assent to this contention. It is no doubt true that the literal meaning of the word substitute is to replace, but the question before us is from which date the substitution or replacement of the new statute took effect. There is no deeming clause or some such provision in the price control order to indicate that it is intended to have a retrospective effect. This line is important. It is a well-recognized rule of interpretation that in the absence of expressed words of appropriate language from which reciprocity may be inferred, a notification takes effect from the date it is issued and not from the prior date. The principle is also well settled that statutes should not be construed so as to create new disabilities or obligation or impose new duties in respect of transaction which has already occurred. Now, Lordship, the subsequent amendment made in 2015 being neither clarificatory or declaratory. So whether that my right which is occurred prior to 2015, they admit that vacancy exists prior to that, they have never fit up under promotion quota. So whether that could have been impaired, Lordship. The second case is Lordship 1965, AR 1965 HC 1970. In the relevant para 7, 8, and 9.
Which one? 2000 and?
1965 AIR SC 1970. Party name is Amireddy Raja Gopala Rao versus Amireddy Sitaramai.
AR 1960 Supreme Court 1970. Amireddy. Amireddy. Okay, paragraph? Para?
7 and 8. Paragraph 7 may read, okay. We are satisfied that the respondents were entitled to maintenance during their lives out of the state of Dingaya under the Hindu law as it suit in 1948. When Dingaya died in December 1949, the suit was instituted, and also in 1954. When the suit was decreed by the subordinate judge, the question is whether this right taken away by the Hindu Adoption and Maintenance Act 1956, which came into force during the pendency of the appeal to the High Court. The act is intended to amend the codify the law relating to adoption and maintenance into section 4 of the act. So this the act has been prescribed. Let's skip that part. Made it from in terms of next page, Lordship. In terms,
Which line?
it starts from
In terms of section 21, 22.
21, 22 are prospective,
Hmm.
where the act is intended to be retrospective. It expressly says so. The section 18 provides for maintenance of a Hindu wife, whether married or before or after the commencement of the act by her husband. Section 19 provides for the
Okay,
maintenance.
we have
of a-
understood. You want to contend that
A right which has been
the
prescribed.
higher qualification has been prescribed only for
Subsequent
2015, which will
onward.
be post-operative.
Post-operative.
There was no requirement of a candidate being a graduate prior to 2015.
15.
So if your case is considered as if you are before
For
2015,
vacancy which occurred prior to 2015.
then your qualification will not be a bar.
Lordship.
Okay.
Because they admit in the RTI reply, Lordship.
Okay.
That Lordship may kindly peruse, Lordship. At page 28
Of the
writ petition. Point number 1, Lordship. Total 17 number of vacancy of junior assistant occurred from 2005 to 8, which have already been filled up, and no vacancy of junior occurred during the year 2009.
sorry, page
Page 28.
28. Yes,
Point
RTI
reply, Lordship.
28.
Point number 3, Lordship. Total 19 number of vacancy of juniors occurred from the year 2010 to 2018.
Hmm.
And they admit the cadre, point number 4, total cadre strength of junior assistant is 41. So from 41 to Lordship, 10%, 4 posts ought to have been filled up for vacancy which occurred up to 2015. They admit till 2010, in between 2010 to 18, 19 have been filled up. So my contention is that for a vacancy which occurred prior to 2015, Lordship, at least 4 posts ought to have been filled up. as per the cadre strength being 41. So in that case, I don't have a grievance
Total
against
19
the
number of
private
vacancies offered
respondent.
for, 19 vacancies were there from 2010 to 2018.
18,
And when was this amendment 15?
2015.
So you want to just contend that there were vacancies where you could have been?
They did not exercise any out.
Hmm.
That is my contention.
Okay. लिखो.
And not one more thing, we are not given having SCP or MSCP benefit till date.
Yes, technician benefit. You,
My lord, only one thing, my lord. For party two. Compassion appointment, my lord.
compassionate.
No, no, my lord,
Oh, okay, the other.
that's the ratio, my lord.
Okay.
MC Santosh, my lord. So MC Santosh, my lord. That stipulates that the non-prevailing on the date of consideration of an application should be on the basis of consideration on the claim of the compassion appointment, a dependent of it is on the date, my lord. So
No, no, we are not on the first part. We are on the part of ACP, assured career progression.
that is
That he is also saying.
that part, my lord.
Stagnation part, stagnation increment you have to give.
That is, my lord. That would, but
Okay.
not.
One more division bench judgment of Lordship says that there has to be promotional affinity. But 24.
See, if the rules does not have a promotional ladder in certain posts,
That impact has come only on that impact came out.
that has been taken care of by ACP, as added by stagnation increment, all those. There are certain posts
Lordship,
where you cannot go up.
the
That's why-
monetary benefits is not the sole thing, Lordship.
No, there are single cadre posts. What do you do then?
He had the cadre strength is
Suppose in
41.
in this court, there is a post called court manager. They'll go nowhere.
But here he goes.
So
he had
can
the
you say
cadre.
that no, I have to be appointed,
Lordship,
promoted?
he had the cadre strength was 41, Lordship.
That is a different aspect where
They ought to have that you ought to have followed the rule at least 10%. Lordship. 4 posts ought to have been filled up. No, the RTI reply says so.
okay. The grievance raised in this petition filed under Article 226 of the Constitution of India is with regard to the promotion which the petitioner claims from grade 4 to grade 3 under the Assam Ministerial Service. What is the full name of the rule?
District establishment.
District Establishment Rules, 1967. Ito kung sa way madama kita sa nasa. Post para. The facts, the background facts leading to the aforesaid claim is narrated herein below in brief. Full stop para. The petitioner was appointed as
Processor.
process another two petitioners. पहला भी था क्या? The grievance of the पहला first line. Petitioners claim दो petitioner. उसके बाद Okay. The petitioner, while the petitioner number 1 was appointed as a process server on 12/10/1993, the petition number 2 was appointed as a peon on 31/8/1998. In the establishment of the office of the deputy commissioner, which district?
Hailakandi.
The Hailakandi. Full stop. It is not in dispute that both the aforesaid posts are in the grade 4. Full stop. The post in grade 3 has a promotional quota of 10%, which is to be filled up from eligible candidates in the feeder cadre of grade 4, and the qualification prescribed and the existing qualification at that time was prescribed to be higher secondary. Full stop. It is the case of the petitioners that both of them were eligible for such consideration, and in spite of meeting the eligibility criteria, both by means of educational qualification and other factors, the petitioners were not given the benefit of promotion. Full stop. The rules, however, had undergone an amendment in the year 2015, wherein the minimum qualification was amended from higher secondary to graduation. Full stop. The petitioner contends that the rules being prospective in nature, the case of the petitioners can still be considered as they were eligible during the period till 2015, and therefore a direction be issued for their promotion. Full stop. Para. The defense of the state is that consideration has to be done. Any consideration done has to be made as per the existing rules, which admittedly requires a candidate to be a graduate, and the petitioners do not possess such qualification. Full stop. Para. I have heard Sri B. Chakraborty, Learned Counsel for the petitioners. Full stop. I have also heard Sri R. Dhar, Learned State Counsel for the official respondents. Full stop. Sri I. H. Borbia, Learned Counsel, appears for the respondent number 4. Full stop. Para. Sri B. Chakraborty at the outset has submitted that though an incumbent has been made party respondent number 4, the present relief claimed may not be claim would not affect his services and is only for a consideration of the cases of the petitioner for promotion to grade 3. full stop. By drawing the attention of this court to the ऊपर जो लिख दिया था ना Assam Ministerial District Establishment Service Rules 1967 to the rules of 1967, comma, the learned council has submitted that that for filling up the post of grade 3, comma, there is also an avenue to fill up such post by promotion, which is to be done at the ratio. What is the ratio?
90:10.
The ratio 10:90. Full stop. By drawing the attention of this court to the averments made in the petition, including the documents. No, including a response received by application of the RTI Act dated 8/10/2018, comma, the learned counsel for the petitioner has submitted that sufficient vacancies were there till the amendment of the rules wherein the petitioners could have been considered and promoted, full stop. He submits that the rules, that the amendment being prospective in nature, comma, that the amendment not having any clause that the same would have a retrospective effect, comma, such additional qualification can be held to be necessary only post 19. What is the date? Post 2015. And therefore, the petitioners petitioners would possess an indefeasible right for consideration of their cases for the period prior to 2015, full stop. Para, in support of his submissions, comma, the learned counsel for the petitioner has placed reliance upon the following cases. You don't know, huh? Number 1, EIR 1965, Supreme Court 170, Amir Reddy. Number 2, 1976, 3 SCC 37, Vijay Lakshmi Rice, so and so, huh? Para. In the case of Amir Reddy, Supra, the Honorable Supreme Court has laid down that unless a statute is intended to be retrospective, which is expressly made, comma, the effect would only be prospective in nature, full stop. In the case of Vijay Lakshmi Rice, comma, the aforesaid proposition has been reiterated, full stop. The learned counsel has also raised the aspect of assured prospect of has also raised the issue that the petitioners have not been given the benefit of assured career progression and they are stagnating in the same post. Full stop. Additionally, comma, the learned counsel for the petitioner has also relied upon an order dated 15/6/2023 of this court passed in WPC 3797 of 2020. Within bracket Dinesh Kumar Singh versus State of Assam and others. Puts the para. Per contra, comma, Sri Dhar, the learned State Council, has submitted that the writ petition itself has been filed in the year 2020, which is much after amendment of the rules in question. Full stop. It is his contention that any directions for consideration has to be consistent with the prescription of the rules, which presently requires that a grade 4 employee should possess the qualification of being a graduate so that he can be considered for promotion to the next higher grade within bracket grade 3. Full stop. He further submits that the contention of the petitioner that contention of the petitioner that they ought to have been considered and promoted prior to 2015 would be of no relevance, as there was no grievance raised during the said period of time. Full stop. It is further submitted that there being no challenge to the prescription of the present rules, comma, no relief can be granted to the petitioners. Full stop. Para. Sri Borbhuya, learned counsel for the respond number 4, endorses the submission of the learned State Council and has further submitted that his client possesses the requisite qualification of being a graduate and therefore no fault can be attributed in the process of his promotion. Full stop. Para. The rival contentions have been duly considered and the materials placed before this court have been carefully examined. Full stop. Para. The basis of the present claim is the earlier rules which existed till the year 2015 when an amendment was brought into effect. Full stop. Prior to the amendment, comma, the minimum educational qualification prescribed for being promoted to the post of grade 3 was higher secondary. Full stop. This court has, however, noticed that no grievance was ever raised in the period.
In 2013, I have submitted a representation,
No,
page 19.
Not representation, case. No grievance was ever raised by filing any case by the petitioners prior to 2015 when the amendment had come. Full stop. Though the learned counsel for the petitioner has submitted that a representation was filed in the year 2013, comma, unless such cause of action was espoused in that relevant point of time, comma, filing of a representation would not give any vested right to the petitioners. Full stop. Para. The trust of the learned counsel for the petitioners is that there being no express language employed in the amendment of the rules of 1967 made in the year 2015, that such amendment would be retrospective in nature, comma, the petitioners can still be considered since they had the requisite qualification till the amendment had come into force, full stop. The aforesaid contention, however, cannot be accepted by this court, as any direction for consideration has to be in consonance with the present rules, full stop. The matter would have been slightly different if the lease was before this court in a period prior to 2015, where the minimum qualification prescribed was higher secondary. Full stop. The the reliance to the cases by the petitioners would not come to the aid of the petitioners, full stop. In the case of Vijayalakshmi Rice Mills, comma, the observations of the Honorable Supreme Court in paragraph 5, which has been relied by the petitioners, would clarify that the said observations were made in view of certain transactions which were complete before the amendment had come into force, full stop. For ready reference, comma, the relevant part of the said paragraph is extracted herein below, full stop. The page ये बोला हाँ प्रिंसिपल द प्रिंसिपल से यहाँ तक green flag, huh? Yeah, green flag. The observation of the Honorable Supreme Court in the case of Amir Reddy that an act would be held to be retrospective only if it expressly says so is a settled position, full stop. However, the said position would not be of relevance to the present case, full stop. This court has also observed that reliance on the case of Dinesh Kumar Singh Supra would not come to the aid of the petitioner, as the issue therein was a different one, wherein the incumbent in the said case, who was appointed on compassionate ground, had raised the dispute with regard to the subsequent promotional avenues by a different branch of the government, full stop. Para. This court is also of the considered opinion that though the petitioners have obtained information under the RTI regarding existence of vacancies prior to the amendment, comma, in view of the present litigation being instituted in the year 2020, which is much after the amendment of the year 2015, comma, no relief, comma, whatsoever can be given to the petitioners, full stop. Accordingly, comma, the writ petition stands dismissed.
Notwithstanding the dismissal, MSCP benefit
Oh,
that may be
yes.
considered.
Yes. Though the petition has been dismissed, comma, the aspect of assured career progression and oblique or stagnation increment is a valid aspect which has been raised by the petitioners, and that aspect is required to be looked into. And whatever benefit is available is required to be paid to the petitioners in accordance with law. Yes.
My lord, the brief and factual fact of the case is that the petitioner, petitioner,
Yes.
our engagement,
Hmm?
petitioner engagement was 28/12/2005. From since that, he was servicing in the Chandra Kapanchal, petitioner. Petitioner, annex 3, my lord.
Wha-
28. So, after my lord, 20,
You were appointed where?
Huh?
Where were you appointed?
on appointed my lord, 28 Baro,
Where?
Chandurai Kapanchal,
Huh?
Chandurai Kapanchal, Chandurai,
As what?
Agoni block,
As what? Appointed as what?
appointed at Chandurai Kapanchal.
As what?
Huh?
What was the post?
Pion come together. Forget.
When was the appointment?
My lord, engagement letter is my lord, annex 3, annex 3. It was the 1718, my lord. Page.
Yes.
Fourth article. But in this matter, after the change of notice of motion, my lord, it has come for 2 times, my lord, but both dates on the 4th date, my lord, matter were adjourned, my lord. So we don't have any copy, my lord. So from my side, from department assistance, it's some,
Copy was not given.
initially another advocate was there, my lord, after our engagement, my lord. But then
Matter of which year?
we have to reconstruct the file, 2021, my lord. After a phase of notice of motion, my lord, it was listed 2 times on 2022 and 2024. On the both dates, matter were adjourned, my lord. We tried to contact the
And you are for whom?
private residence.
Let us hear. If there is
Yes.
any requirement, we'll give you
Yes,
time.
yes, yes.
I have given my lord. Copy to given. Certificate. Yes, of course.
Okay, you continue, Mr. Das.
Mr.
Where
Das,
is your appointment?
my lord, 17.
Page 18,
17. Page 17.
17,
17, 18, my lord.
18,
18, my lord.
your appointment, your
Engagement.
Manawar Hussain,
Manwar Hussain. So after the annex 4, my lord.
2812,
Hmm.
you are appointed.
Hmm.
Sindurai, GP.
Chandurai Kapanchal.
Where in which district?
After was
Dhubri.
Dhubri.
Okay. Then what happened?
My lord, after in the year up to 2010, my lord.
Hmm.
On suddenly, my lord, on 27/9/2010, I am no any advertisement. Per my lord, 10.
Have your
10
seat.
page 8.
Have your seat. Why are you standing?
Hmm.
Have your seat.
Suddenly, my lord, I am debarred from the post. Without any advertisement, Noor Ali Ahmed was appointed in connivance with other.
You are Noor Ali.
No. Now Noor Ali is not, my lord.
When
With-
was Noor
Noor
Ali?
Ali Ahmed.
2010.
2000,
In your place, Noor Ali was appointed.
afterward, in the year of 2010, my lord.
In your place,
In about.
you were discontinued.
No, in my post.
Okay.
I was debarred by the committee without any key, notice any key. Debarred on 27/9/2010. No earlier amount appointment. After that, I filed afterwards I filed a WBC case, and this case was withdrawn by another advocate. Afterwards, Noor Alam is now not in the post. Now Jahangir Alam is, my lord. Respondent number 8 is appointed. Jahangir Alam.
You had earlier filed 1705 of 2011, then withdrawn.
Withdrawn by another advocate. And afterwards, now Noor Ali is not in the post. Now Jahangir Alam, son of Johar Ali, Johar Ali, my lord, page 10, para 12, Jahangir Ali, the brother of the tax collector of the state government, my lord. State government. Then afterwards,
Page.
page 10, para 12, my lord.
No, that order.
Order. Engage order is, my lord, page 37. On a key resolution. As per resolution, my lord.
Where is Jahangir Ali's appointment?
Jahangir Ali, my lord, Jahangir Ali, my lord, page 32, my lord. Page 32 to 37.
This is 2004.
This is, my lord, it is totally false document, my lord. False document.
2004.
False document. False. It is false document. Where after I filed RT application, I was furnished this document. I made an RTI application. Why Noor Ali is appointed? Why Jahangir Ali is appointed? It is false document, my lord. Then my lord, I filed. I go to the president, Taslim Bibi, first document, the president. Who was the president? It is the first document, my lord. First document. My lord, then it is included in the para. There the petition state that the state Noor Ali Ahmad is now not in the state post, and now one Jahangir Hussain, page 10, para 12. Or the state GP was appointed in the state general GP, arbitrary and conspiracy, and access. After getting the impression of state Jahangir Hussain, son of Johar Ali, is now at the state court of Pune Chowkidar of the state general GP, he made a RTI application dated 4/1/2010 to the state general GP, and the state general GP had dated 13/2/2010 to give him a RTI reply regarding the appointment of Jahangir Hussain, son of Johar Ali, as Pune Chowkidar, who is false and manipulation by the recent general GP, because after getting the state RTI reply regarding the appointment of the state Jahangir Hussain, son Johar Ali, he made Taslim Bibi, wife of Jahangir Ali, resident of village Shendura, post Belguri, PS Agumani, district Dhubri, Assam, pin Stone. Then the president of Shendura GP of the year 2004, and also other members said the GP of the state year incurred them about the state appointment of Jahangir Hussain, dated 13/8/2004, regarding RTI reply dated 13/2/2003 by state temporary. The then President Taslim Bibi, Shendura GP of the year 2004, has replied that her signature is in the resolution regarding appointment of Jahangir Hussain is not her own signature, which is false or manipulation of this recent Shendura GP. The other members of the state GP of the year 2004 also have replied to him that these are not their own signatures. It is the main case, my lord. Afterwards, they filed the affidavit and revision. I also filed RTI. I also reply of the case. My lord, kindly see my reply. Legal notice I filed to the president, Taslim Bibi, of the 2004. RTI reply, my lord. My lord, kindly see APTP in reply filed by the petitioner, my lord. Annexure 1, my lord, the copy of the legal notice dated 26/5/2022. Page 76 and 78. My lords, kindly see a copy of reply legal notice, my lord, 79 to 88. And 79, kindly see, my lord, a reply.
Yes.
My lord, kindly see para 2 and 3, my lord. The J. Talukdar, advocate of Dhubri, on behalf of the then President, Tosmia Bibi, of the India year of 2004. Kindly see, my lord. That on 13/8/2004, no resolution was adopted to appoint Jahangir Hussain as a peon cum central GP, and a false and fake resolution was prepared by Jahangir Hussain, putting for signature on so-called resolution joining report dated 14/8/2004, and a reply of legal notice issued on 26/5/2022. Reply of legal notice of the petitioner that on 1/1/2006, Manwar Hussain, son of late
This,
Kanser,
your legal notice you had sent by what communique, what mode? Was it by registered post?
yes, my lord.
Where is that thing? When was it posted?
Page 74, my lord.
Where is the registered post?
It is on registered post, my lord. The petition also met with the legal counsel to the house of the Tosmia Bibi, my lord. Across the
How was this served upon Taslima Bibi? How was this served?
on registered post, my lord.
Where have you stated? Where is the material?
It is not given. It is not given, my lord. I will find this letter, my lord. I will find it later. I will find it later. It is in my file also, but it is not in my clerk not given. Registerable, my lord. Afterwards, my lord. After my lord, and the advocate of the Tosmia Bibi, learned consultative, on perhaps kindly see, my lord. So, on 1/1/2020, Manwar Hussain, and Samsar Ali, Destina Village Pavastra, for Dagmuni Eton, appointed a peon after due resolution. Under the above facts and circumstances, it is hereby clear that the Jahangir Hussain was not appointed as peon of Central GP on 31. Rather, Jahangir Hussain was appointed as peon of Central GP, and all documents collected by Jahangir Hussain are fake and did not issued from my client, and a legal action should be taken against Jahangir Hussain as per law of the land. Afterwards, my lord, the petitioner filed an FIR before the Agoni police station. FIR copy is also, my lord, is 83/85. Against the respondent number 8, it is the case, my lord. It is humbly paid deputy general court, my lord, to take aside the input resolution copy of the respondent number 8 and make me restatement in the portal peon cum Chowkidar in Chandrai apartment. In the interim, my lord. Resolution appointment of respondent may be estimated in the interest of justice, my lord.
What happened to this case? FIR,
Well, my lord, case,
what happened thereafter?
the case is registered, my lord.
Then,
Then case is registered, but not starting, my lord, in the court.
it was in 2022.
FIR dated 83 and 85.
22/6. 22/6.
In respect of the RTA reply of the concerned advocate, Dhuburi Bar Association, the FIR is filed against the respondent number 8, my lord. And the FIR was registered.
See, your appointment was of 2005.
Yes, my lord.
That was discontinued by, in the year 2010.
Yes, my lord.
One Noor Ali was appointed. You filed a writ petition. You withdrew, the writ petition was dismissed as infructuous in 2017. Now, thereafter, you have filed this writ petition when? 2021. How do you explain the delay? The delay part, how do you explain?
My lord, when Noor Ali Ahmad is engaged in instead of me, then I engage another advocate, party advocate, without any taking instruction of me, petitioner. He withdrew the case.
That is another matter, but Noor Ali is not there. Now Jahangir has come. Jahangir had come in the year 2004 itself. Yes, yeah, for Jahangir.
Yes, sir.
What do you say?
My lord, I have filed affidavit, my lord. Kindly see, my lord, page 55. First resolution in 2004, my lord, 13/8/2004. Resolution number 1, page 56.
Yes.
My lord, as per resolution, I was appointed, my lord.
But he says that Taslima has denied her signature.
No, my lord, not that is my lord, communication between two advocates, but I have not been issued any note, my lord, legal note. So without informing me, my lord. And Taslima is not a party in petition. She could have been a party. Then, my lord, kindly see page, my lord, page, my lord, page, my lord, 62. It's my appointment. My appointment is as per the, my lord, resolution of the, my lord, governing body, my lord.
Now, the reference to one Noor Ali,
My lord,
it came when? Which year?
Noor Ali is not a party in the petition.
No, Noor Ali was appointed when?
Noor Ali, my lord, Noor Ali are 27/9/2010. My lord, even my representation. My appointment is 2004. And resolution is also my on hand, but it is not annexed, this petition.
Which is the order? Page.
My lord, my lord, my lord, representation, annex 12, my lord. Annex 12, the order is not annexed here, my lord. This is the order. Annex 12, kindly see, my lord. Annex 12, 13, 14, 15, my lord.
Page.
Page 88, 38, 43.
38.
43 and 44, 46, my lord. 44, 46, my lord. 38.
These are your representations.
Repeated, my lord.
Where is any materials from the authority from where we can come to a conclusion that in the year 2010, one Noor Ali was appointed. Where is that official? document?
RTI application, my lord.
Where, reply, where is the reply?
Manwa,
Reply,
reply, RTI.
where?
This is Annex 8, my lord. Noor Ali was encased and open.
Page,
Noor Ali, Annex 8. Annex 8. Annex
annexure?
8, Annex 8. Annex 8, Annex 8, page 27, my lord.
So this is your application.
Yes, my lord.
Where is the reply?
My lord, the resolution copy was in my hand, my lord. But it is
Where is
not.
the reply? Any document? to show-
Yes, my lord, my lord.
So
It
it's
is
not-
the good, my lord. Yes, it is not annexed, my lord. It is not, I will,
Sir Islam, what is your case?
my lord, my case is, my lord, I was appointed in 2004 as per the resolution. Kindly see page, my lord, 61 is the resolution. It's starting from page, my lord, 57. The, my lord, photocopy of the, my lord, records.
Where is the origin, where is the concerned part? Page-
My lord, concerned part
page
is page, my lord,
56.
61. Resolution number 1.
Page 61,
May I read, my lord?
yes.
অবাধ নৱগঠিত পঞ্চায়তৰ কাৰ্যালয়ৰ বাবে দান কৰা মূল্যৱান ভূমিদাতাৰ পুতেকক পদত পুতেকক পঞ্চায়তৰ কাৰ্যালয়ৰ যিকোনো পদত নিযুক্তি দিবলৈ উপস্থিত গাঁও পঞ্চায়ত এলেকাৰ দায়িত্ববান ব্যক্তিসকলে অনুৰোধ জনায় কাৰণ ভূমিদাতাৰ ত্যাগৰ বিনিময়তহে পঞ্চায়তৰ কাৰ্যালয় স্থাপন কৰিবলৈ সম্ভৱ হৈছে। ৰাইজৰ অনুৰোধৰ ওপৰত ভিত্তি কৰি কাৰ্যালয়ৰ বাবে 2 বিঘা জমিন দান কৰা জহৰ আলী বেপাৰীৰ পুতেক জহিৰুল জহিৰুল হুছেইনক, respondent number 8, জাহাঙ্গীর হুছেইনক অবৈতনিক অস্থায়ী নিযুক্তি দিবলৈ সভানেত্ৰী সমূহৰ দায়িত্ব আৰু কৰ্তৃত্ব অৰ্পণ কৰা হয়। লগতে বিভাগীয় নীতি নিয়মবোৰ মানিবলৈ পঞ্চায়তৰ আয়ৰ পৰা 500 টকা কৈ মাহিলী প্ৰতি মাহে দিবলৈ প্ৰস্তাৱ সন্নিৱিষ্ট কৰা হয়। এই মৰ্মে জাহাঙ্গীর হুছেইনক অফিস পিয়ন পদত নিযুক্তি দিয়াৰ সিদ্ধান্ত লোৱা হয়। This is the my lord resolution. As per the resolution, my lord, page 60. Appointment was issued by the my lord president of the my lord Town Panchayat. The my lord type copy is my lord page 63. Appointed made on my lord 13/8/2004. A copy was forwarded to the my lord chairman, secretary, block officer, block, secretary of the government, petitioner concern. Then my lord kindly see petitioner page 64. Petitioner joined my lord immediately on 14/8/2020, 2004, my lord. My lord, photocopy is page 65, joining report, which was duly accepted, my lord, by the president, my lord. Supreme. Then my lord, can you see the my lord last my lord Annex T, page 66. The certificate issued by the my lord secretary, my lord. Recent secretary, my lord. Recent secretary as per record. My lord, kindly see, my lord. Jahangir Hussain, son of late so Sandurai Pattu Akomoni, and he has been working as CPPN since 14/8/2004 till date as per record, my lord. So, my lord, the petitioner is still working, my lord. This is my case, my lord. And my lord, the petitioner is my lord
Not
appointed in
petitioner, R8,
Jahangir.
not petitioner, R8 is
My
working.
lord, R8, responded now. Sorry, my
You
lord.
said petitioner is working.
Sorry, my lord. My lord, the petitioner.
Suddenly, Mr. Das started smiling. He was very happy.
My lord, Alice. My lord, my lord, petitioner, my lord, appointed in 2005. He was terminated in 2010. Thereafter, he discontinued, my lord. Then, my lord, and his applications, my lord, reveals the same, my lord. That since 2010, he was not in service, my lord. Then he filed application for continuation of his course. It
No,
was
see,
rejected.
Mr. Islam, the entire case,
My lord,
which we have understood,
my lord,
that initially one Noor was posted in his place.
my lord.
That was the subject matter of challenge filed in the year of the writ petition of the year 2011.
My lord.
The said writ petition was withdrawn, dismissed as infructuous.
Without liberty, my lord.
Infructuous.
No
In
liberty.
the meantime, he has come to know that your client has been shown to be appointed in that post from 2004.
Well,
And he, in the meantime, has also
I filed RTA, my lord.
exchanged some legal notice reply by which that president
Well,
has denied her signature, that there was no such resolution appointing you.
well,
That is the projection made.
Well,
You, on the other hand, are trying to lead us to the resolution as well as certificate given by the secretary.
Well,
Secretary's certificate is of recent origin, may not be very helpful.
Well,
2021.
well,
But you have given the resolution. So ultimately, the question is whether that resolution was properly adopted or is it a fake resolution? That is the only
That is
answer.
the authority will say, my lord. And if, my lord, it is fake, my lord, the forensic is available to, my lord, justify that. I am ready to say something. My
But
lord,
Mr. Islam
my lord,
appears,
kindly see page 30, my
no,
lord.
Mr. Islam appears to be correct in contending that Taslima is not a party.
My lord,
The exchange of communication is between two lawyers.
my lord,
We do not know. It may be correct, it may not be correct.
my lord, I give
And
RTA.
therefore, we had asked you, where is the
Yes,
postal receipt
Right.
that this application, that this legal notice was indeed sent to the party and not to the lawyer? Because it's very easy to have two lawyers exchanging.
and I have not been informed, my lord. My lord, kindly see page 30, my lord.
30.
Page 30. And Noor Hussain is also not in party. Page 30, my lord, if to the public information officer, some general secretary, Chendurai, Kapanchayat, Chendurai, post Belaguri PS, page 30, my lord.
Yes.
An application under section 6, 7, 8, and 9 of the right to Information Act 21. I am Manowar Hossain, son of Samsar Ali, a resident of village post office of PS, Agami district, Dhubri, and so. Dear audience, on which ground I was prevented by your office to continue my job as peon cum chokidar in your office, Chendurai, Kaya Punjab from the year 2010. Please submit the reason. 2 number point, on who is dead and on who is down, Noor Ali Ahmed, son of Liakad Ali, village Kendurai, part 2, post Belgur, PS, Akuman district, Dhubri, Assam, pin 7 also, then opinion Kendurai, Kaya Punjab. Why was now not in job in the said post? Please give reason. 3 number point, in which ground, Jahangir Hossain, son of so and so, was appointed PN comes Chokidar by your office, do this job and PN goes together. Submit the reason. No answer.
What is the date? What is the date?
Huh?
Date.
Date for 1/2000.
Huh?
For date my lord 2020, 22 nothing. It is
What is
not
the-
eligible. My lord.
What is the date?
For 04/01 20. 20 my lord. 20. My lord. My resolution copy of Noor Ali Ahmed also in my hand, my lord. I will next produce, my lord, in the interest of justice. What is true or what is not true. And also the legalities also on registered court. I also may produce the state ticket, my lord. The petition also communicated to the then president, my lord, Tosnevi, on the house. And
See,
he
your RTI application was replied at page 31.
said, only
31 by the secretary.
by
When in the
the resolution copy, my lord, only resolution copy.
yes, resolution copy has been given of 2004. Why should we disbelieve this resolution copy?
Only resolution copy of Manwar Hossain, my lord, and reply.
Yes.
Only resolution copy of the resolution copy of engagement of respondent 8 months.
Yes.
Only.
That is what you want. It has been given.
No, my lord. I want such instruction, my lord, such information, my lord, but the only this reply only furnished to me.
Ultimately, it is a dispute of facts. How can you go into?
I may implement, my lord. Trust me, I may, for the interest of justice, I may implement. Trust me, baby, and the secretary of Sanjay Government for the interest of justice. It is totally false and fake. The learned advocate of the Tasmania BB served me legal notice. Served me legal notice that it is totally false. All documents selected by the respondent 8 are false and fake, and any legal action be initiated against you, in the reply mail. In the reply mail. Reply in the reply document. And as in regard to that reply, the petitioner filed a FIR before the concerned Agoni police station, man. And the case is registered, my lord. And now the case is
FIR has been lodged long thereafter.
responded.
FIR is at page 83. When is the date of what is the date of the FIR?
FIR lost on my lord,
2022.
22.
22.
My lord, and he was debarred as per his application, my lord, in 27/9/2010. So you have to file in 2010. Getting total information, total real information, factual fact that as per reply of the legal notice, it is clearly known. Then the consent FC of the Agoni PS.
Mr. Chalia, which matter? Which matter? 15. What was the matter? Sorry, we kept you waiting. What is the matter? Health department? Health. Who is health? Yes, madam. Are you ready with the matter? Not received. Senior counsel is waiting.
Because they have relied on a letter of 17 on the basis of which the appointments were not made. And
Again, if you can have it day after tomorrow if you
Fine.
want. Will you be able to get the instructions? On 17th or next week, whenever you say, matter which year? Matter which year? 22. We can have it next week.
Only,
No, not your case.
My lord.
my matter, my lord. It is the interest of justice, my lord. I am dictated from the, I am in dictation, my lord.
Mr. Das, you are not the counsel for all the cases. You cannot make a common prayer like this. We'll have it on Thursday or next Thursday, not this Thursday, next Thursday. Is it okay? That means on the 2nd, if it is not inconvenient, 2nd of
2nd of May.
May. Item number, yeah. Archfree DP Chalia, Learned Senior Counsel for the petitioners, full stop. Miss A. Bora, Learned Standing Counsel Health, however, submits that instructions are awaited, full stop. She accordingly pays for and is granted time till 2nd of May 2024, full stop. List accordingly on 2. Okay, what do you do in this case?
My lord,
Yes, Mr. Doctor.
Discussed all the issues, my lord. Moreover, Lordship may kindly come to prayer of the case. The petitioner didn't challenge their termination order.
He has. Should I directing to make the petitioner reinstatement? He has prayed for reinstatement. We have seen that.
Prayed for reinstatement, my lord. But one order is there, resolution, my lord, annexed. As per that, my lord, one CEO's order is also there
Page.
to discontinue, my lord.
CEO means
Chief Executive Officer.
CEO.
Page 23, part of the resolution, my lord.
Yes.
May I read, my lord?
Yes, please.
আজিৰ সভাত ইন্দুৰাই গাঁও পঞ্চায়তৰ পিয়ন শমশেৰ আলীৰ ল'ৰা মনোৱাৰ হুছেইনৰ যোৱা গাঁও পঞ্চায়তৰ কাৰ্যকৰী কমিটিয়ে এখন অৰ্ডাৰ দিয়ে। উক্ত অৰ্ডাৰ মৰ্মে পঞ্চায়তৰ কাৰ্যকৰী কমিটিৰ
23. Yes, yes.
তৃতীয় প্ৰস্তাৱ।
উক্ত সভাপতিৰ
আজিৰ সভাই
Yes.
ইন্দুৰীয়া গাঁও পঞ্চায়তৰ পিয়ন সভাৱে আজিৰ ল'ৰা পঞ্চায়তৰ কাৰ্যকৰী কমিটিয়ে এখন অৰ্ডাৰ দিয়ে। উক্ত অৰ্ডাৰ মৰ্মে পঞ্চায়তৰ কাৰ্যকৰী কমিটিৰ ৰেগুলেশ্যন নম্বৰ 3 dated 24/12/2005 that was also not annexed, my lord, that resolution, my lord. মৰ্মে মনোৱাৰ হুছেইনক মাহিলী 500 টকা ভিত্তিত অস্থায়ী হিচাপে এখন নিযুক্তি পত্ৰ দিয়ে। সেই নিযুক্তি পত্ৰ হিচাপে মনোৱাৰ হুছেইনে 2006 চনৰ জানুৱাৰী মাহৰ পৰা পিয়ন হিচাপে সিন্দুৰাই গাঁও পঞ্চায়তত কাম কৰি আছে। নেক্সট পেৰাগ্ৰাফ। আজিৰ সভাত কিন্দুৰাই গাঁও পঞ্চায়তৰ পিয়ন শমশেৰ আলীয়ে অহা 30/11/2013 অৱসৰ হ'ব বুলি চিইঅ'য়ে দিয়া চিঠিখন সভাত সভাপতি হিচাপে পঢ়ি শুনায়। That means there was a letter, my lord, from CEO, Chief Executive Officer, maybe terminating or
No. আজিৰ সভাই খেন্দুৰাই গাঁও পঞ্চায়তৰ পিয়ন
শমশেৰ আলীয়ে অহা 30/11/2013
There is somebody else, not the petitioner. What is the
Shamsher
name of
Ali
the-
is the father of the petition.
Okay. Then, yes, Shamsher Ali. Then what happened?
অৱসৰ হ'ব বুলি, that means, my lord, maybe he was working because his father was
Read the entire,
pion, my lord.
Shamsher Ali.
চিঠিখন সভাপতি চাহাবে পঢ়ি শুনায়। বৰ্তমান কাম কৰি থকা শমশেৰ আলীৰ ল'ৰা মনোৱাৰ হুছেইনে সভাপতিক উদ্দেশ্য কৰি এখন দৰখাস্ত জমা দিয়ে। সভাপতি চাহাবে দৰখাস্তখন সভাত পঢ়ি শুনায়। পিছত বহুতো আলোচনা বিলোচনা অন্তত শমশেৰ আলীৰ ল'ৰা মনোৱাৰ হুছেইনক অস্থায়ী ভিত্তিত মাহিলী 900 টকা হিচাপে গাঁও পঞ্চায়তৰ তহবিলৰ পৰা আদায় দি ফাৰ্ষ্ট
কৰিবলৈ উপস্থিত সদস্যই
আদায় কৰিবলৈ
একমত
উপস্থিত
হয়।
সদস্যই
একমত হয়।
Yes, that
সদস্যই
means
একমত হয়।
as per this resolution, he was appointed in a
rupees 500.
Okay.
But I can understand, as per my understand, my lord, his earlier maybe his father was chowkidar in this post, my lord. After his retirement, he
was temporarily given.
Yes, temporary. And
This-
both the private petitioner and the private respondents were appointed temporarily. And as per law, that is not legal, man, because appointing authority of chowkidar is not the president or the any committee, man.
And how did Mr. Islam's client? Come
He's
into-
also temporarily, on purely temporary basis is working. And both the documents I have checked, my lord, with the seal of the government authority. So huge factual disputes is there, my lord.
Now, is a post of chowkidar contemplated by the rules?
There are
Is-
two kinds of
If the panchayat on their own engages a chowkidar and gives the salary from their own exchequer, that's a different matter.
Yes.
And if the appointment is officially done,
Yes,
then
that is it.
then that amount will go from the government's exchequer.
Yes. There are two types of posts, my lord. First type, my lord, appointed by the PRIs, and second, my lord, by the directly from the government, the direct commission. And these both the appointment letters were issued by the president. Purely
No,
temporary.
his contention is that though he was appointed in 2010, this is 2010, isn't it?
As per him, 2005, my lord.
No, this resolution.
Yeah, this resolution 2010, my lord.
Then how
Maybe
can-
because of this resolution, that matter was become infectious.
No.
That are different petition, my lord.
No, he
Third
says,
party,
he says that this is of 1906 or 1908. What is the date?
1906, 1908.
1908. On 27/9/2010, almost after a year, no, after a month, he was discontinued and Noor Ali was appointed. That was the subject matter of challenge in the earlier writ petition 1705 of 11.
Maybe. So there are lots of factual disputes are there, my lord. Maybe because of the changes of the panchayats, my lord, they were appointed by themselves.
No, is there any mention about Jahangir in this resolution of 2010?
2010, in this resolution, there is no mention.
No, if Jahangir was already appointed as chowkidar and working since 2004,
Yes.
where was the requirement?
That is why, my lord, something is very fishy, my lord, because three persons are claiming in the same post on different periods, my lord. Are claiming they are continuously work. Three different persons.
Has-
Only one post.
First the petitioner, after was Noor Ali Ahmed, after was Jahangir. So in coordination with the committee member. This Jahangir Hossain is the father of the collector of the panchayat, own brother. The resolution copy of Noor Ali Ahmed also.
Mr. Datta, you get instructions.
Yes, that is why, my lord, before
You
starting,
get the
my lord,
instructions.
I prayed for time sometime.
Heard. Sri A. Das, Learned Counsel for the petitioner. Also heard Sri S. Datta, Learned Standing Counsel, PNRD. Whereas Sri M. Islam, Learned Counsel, is present for the respondent number 8. You are there? D. Bora for the state respondents. Full stop. Certain factual disputes have been raised in this petition. Full stop. Factual issues has been raised in this petition which are disputed in nature. Full stop. Though this court may not go deep into such factual disputes as it is not within the ambit of the exercise to be conducted under Article 226 of the Constitution of India, Sri Datta, the Learned Standing Counsel, is directed to obtain instructions on the following aspects. Full stop. Number one, appointment, comma, if any, of the petitioner as chowkidar in the
Peon cum
as peon cum chowkidar in the Sindurai Gaon Panchayat, Dhubri, which he claims is through a resolution dated 12/8/2010, comma. Number two, appointment of one Noor Ali in the same post with effect from 27/9/2010 and the consequence thereof. Number three, appointment of one Jahangir of Sri Jahangir Ali, the respondent number 8, in the same post as claimed from 13/8/2004.
My lord,
Full stop.
I want to say something, my lord, in this regard. Annex 15, page 41. I give representation to the Commissioner, Panchayat and Rural Development and Assam, Panjabari. And in this copy, the petitioner filed the annexed copy, my lord. Page 45.
Let him have the instructions on this regard. Everything will be clear.
Noor Ali Ahmed resolution copy also.
Yes, when, Mr. Doctor?
Please 40.
List, we'll fix a date.
Madam.
List this case on on 20th of May.
My lord, may I tell you, reply by protection of document under order. 14, my lord.
Parties may exchange affidavit in the meantime.
Jahangir, there, my lord.
Jahangir Hussain, huh?
I'm praying.
I want to production of document, my lord, of Noor Ali Ahmed.
We said,
It is legal, publish, my lord.
question of parties may exchange further affidavits. Not Jahangir Ali.
Jahangir.
Thank you, Hussain. Thank you, Hussain.
Hussain.
Respond number 8. But in the interim, my lord, the service in the interim, my lord,
What
the post
interim?
of the service of the Jahangir Hussain respondent may be stay, my lord. In the interest of justice. Till the
Why,
dispose of
what
the
will
case,
you
my lord.
gain? Will you gain anything?
In the interest, my lord, my lord.
No, what interest? If they do not have a chowkidar and peon, how will they run? Suppose we grant this stay. Without a chowkidar and peon, how will the panchayat run?
In the interest.
In the interest, we appoint
Take
you.
document, my lord. It is
You should have said that in the interest, you please appoint me. We'll appoint you. Without hearing.
Publish, my lord. What should pass order I will follow.
Okay, you file additional pleadings if you want.
Oblige.
Okay.
Oblige, my.
All right.
Yes, 14.
This is your lordship. Your lordship, the petitioner is a plumber, your lordship, requite plumber. He applied for the said post of Assam Rifle Tech tradesman recruitment, really 2018 to 2019. Here, your lordship, impugn order was issued on upon him, your lordship.
File affidavit.
Yes, your lordship, pleadings completed.
Okay.
Already matter has been heard in 3 times, your lordship. Your lordship, on dated 21/4/2021, which I have annexed page number 33 to 34, your lordship.
What is the issue now?
Impugn order dated.
Now, what is the issue?
Here, your lordship, he was discharged from his service, your lordship, showing that unsatisfactory progress in training. Your lordship, they had filed their affidavit, your lordship. I would like to take their affidavit in opposition. Annexure 2, your lordship. Page 15.
Yes.
Conduct of recruit training, your lordship, and that is a scope of SOP, your lordship. as per the guidelines, your lordship. That
Yes.
is, your lordship, praises basic training, your lordship, clerk, then medical EME engineers weeks that
Yes.
has been given in tabulation, where it was clearly mentioned that 23 weeks multiplied by 3 times, your lordship. 23 weeks each. 23, 23, then 23, your lordship. And there, your lordship, 3 chances has been given to the petitioner, your lordship. My only prayer is that he does not get sufficient time. First relegation that has been happened to him, your lordship, that is, your lordship, 20 weeks, 3 days. Training started at 10 January 2020, whereas the first relegation that has been started on 1/6/2020. And if we calculated the days as per their SOP, your lordship, I had made that tabulation, your lordship. Written submission has already been submitted by me, your lordship, which I am reading, your lordship. My written
We may
submission.
not have time today. Well, this will require some
Yes, sir.
application of mind.
My only arising issue is that he does not give your lordship sufficient time as mentioned by their tabulation, that is 23 weeks each, your lordship. That is 3 weeks, your lordship, 23 into 23 into
You want to
20.
contend that the period which has been
The period,
envisaged,
yes, your lordship.
envisaged in the SOP,
SOP.
that period has not been given to you in adequate.
Yes, your
the-
lordship.
The prescribed period. Therefore,
Prescribed period.
the conclusion which they have arrived,
Yes,
that
your lordship.
your progress is unsatisfactory, that is not proper.
Not.
What is your immediate response?
It's not like that. Also, it's an every time 20 weeks, it's not like that. First litigation, when he will appear for the first litigation, that is for after 23 weeks. If he fails, then he will join the next group, which is coming. Then if he again fail, he again back to the next group, which is coming. Like this way, he has been given 3 chances. And thereafter also he again failed. In 3 chances he failed. Thereafter also one special chance has been given to him. In that case also he has failed. That's it. It is not
4
like that in
times.
23 weeks, after that into 23 weeks, it is not like that.
But it
One
was
person
late
has
by
failed.
then.
Suppose he has failed in matriculation. Thereafter he will join the next group. Thereafter he will join the next group. It is not that after 2 weeks he separately exam will be conducted for him. It's not like that.
No, your lordship, my only issue is that he has already passed and cleared all the relegation, your lordship. The final relegation that is on physical proficiency test, your lordship, that is PPT, where he has failed, your lordship, in DIG. Otherwise, if he would not been passed, your lordship, earlier exams, he would not been sent to the DIG check test. That is the final check test, your lordship, where he has applied, your lordship, where test has been conducted. And your lordship, in that test, your lordship, he already passed BPET, that is Battle Proficiency Physical Efficiency Test. Only the part is PPT, your lordship, that is Physical Proficiency Test. He had failed. That is only 2 chin-up, your lordship. Arising issue is 2 chin-up. And there, your lordship, one order has been annexed by the opposite side, your lordship, respondent, your lordship. That is Annexure 1, your lordship, of their affidavit in opposition, where with petition 5887/2011, Rahul Singh.
You are in service or not? No, not in service.
No, your lordship, he was in requisite plumber. And here, your lordship, in this order, your lordship, Rahul Singh, where in page number 14, last paragraph A, as the petitioner failed in BPET test 4 times, your lordship. Here, your lordship, he was granted for Battle Proficiency Physical Efficiency Test. He was given 4 times, whereas he is requisite plumber, your lordship. And here, your lordship, for equity relief, your lordship, he was given 4 times. Then why this person, petitioner, was given only 3 chances, your lordship? For equity relief, your lordship, 1 last chance. And here respondent has here respondent has no loss, your lordship, because only 1 chance. If
Here, Rahul Singh's case was dismissed.
your lordship, but the BPT test, your lordship, here, your lordship, arising issue is completely, he was for medical test, medical ground only. And my case is complete separate. But my since they had annexed it, your lordship, so I would like to draw your attention towards the BPET test 4 times, whereas whereas petitioner was given only 3 chances, and respondent has no loss, your lordship, because if he would given just consider 1 chance, your lordship, then your lordship, if
Well,
he would
let us understand page 15. What is page 15? I mean the annexure 2.
annexure 2.
What is this? What are these abbreviations? Relegation?
They had not mentioned it, your
No,
lordship.
no.
that-
What are these abbreviations? We have not understood. Aim of this SOP is to lay down guidelines for executing training. Okay. Relegations means?
Relegations means training period, your lordship.
And the last one, dish of Rex means?
Rest, my contention is only for this one, not that these are for another purpose, your lordship.
Kindly come to page 66. That is the elaborate.
66. 66, yes, please.
Page
Page
66. Huh?
Page 19 on my
67. Okay, 19.
19.
Okay, what is this?
This is
What is rect means? Rect? RECT means? Recruit. Will be trained and tested in the subjects as, okay. Where is his, this is his.
This is the A 1 to 23, first column A, 1 to 1 duration 1 to 23 weeks.
Correct, correct.
Thereafter B, lordship PPT, 22 weeks it has to be done. Thereafter C, lordship 23 PPET. And thereafter lordship will say, lordship the right hand side column lordship. After 23, there is no any mention lordship. Because lordship, if he fails lordship, there will be no second and third attempt lordship. Because if he fails, he will join the next batch lordship. And the entire process has to be complete lordship within 44 weeks lordship. It is the mandatory lordship. Entire process, if someone passed out regularly lordship, the entire process will be completed within 44 weeks.
But that was not stated there, your lordship.
Okay, we will have it on some other day. Today cannot be. Otherwise, pleadings are over. 21 matter. Yes, tell us one day. We'll suggest a date. We'll fix a date.
May 19 or
19 will be
Pleadings are
7.
complete and the matter.
7.
And it is submitted that the matter. Pleadings are complete and it is submitted that the matter can be taken up for disposal in the admission stage. Full stop para. As agreed to by the learned counsel for the parties. List on
9.
on 9.
7 is on election.
on 13th, 14th of May. 14th May. Yes, Mr. Purkasta, what was your matter, yesterday's matter?
Can it be kept as marker, your
Not
keep you?
Yes, later. Yesterday's matter, 18 matter.
I am a my lord, member of my lord Assam Rifle. Then there was 4 rat, pink and pink. And subsequently, my lord, they issued a notice. I was directed to submit my reply. I submitted the reply. And ultimately, my lord, they exercised the power in discharging me from.
So 18 or matter. What am I to say? It should have been called before time. It's an 18 matter. We'll have day after tomorrow.
Tuesday, my next.
Okay, Tuesday then.
Tuesday, my lord, okay, kindly, my lord, acknowledge. Tuesday, my lord, I will have to go to my lord Arunachal on Sunday. Monday, I will be there. Tuesday, in the late night, I will come back. On Wednesday.
Okay, we'll try on second, Thursday. Second, paucity of time.
And in the meantime, my lord,
Did not allow the matter to be.
since I
Full stop para. As the matter is of the year 2018, comma. List on 2/5/2024.
my lord, may I seek a liberty to file reply, my lord, but since
No, 18 matter, what reply?
because they have filed a affidavit opposition. So
That
I-
affidavit opposition was filed into the year 2018. Okay, rest, we'll give dates.
Your lordship, item number 18, 19 and 5. Interim order.
Okay. 18, 19, 25. You are for the
Next Tuesday.
petitioner?
Yes.
Oh, okay, paucity of time, huh? Interim order passed today.
Item number 16, my lord.
On next
We
Tuesday.
get
your
the order of dismissal, my.
Interim order is there.
Not interim.
He'll give dates.
Yes,
Your lordship may take it up on next Tuesday, lordship.
Next Tuesday, it may not be possible. We have
There's a
system.
urgency because they have actually, they have filed two contest. They filed the stay order.
No, not next Tuesday. All of data deliver.
I'll